Okay, thank you, folks. We're back, but before we jump back onto the schedule, I'm going to let my co-chair do an introduction for a little more information before we proceed. Go ahead, co-chair Burkhart.
Thank you, Mr. Chairman. So, spur of the moment thought yesterday, thinking about what we're going to talk about this morning. Dr. Jonathan Brandt, who's with us, and he came in from the field for this. He's been actually working, doing useful stuff rather than sitting in meetings. Agreed to come and talk to us a little bit about some of the work he's doing using coal membranes to clean water, especially produced water. We had that discussion this morning on using produced water for hydrogen production. And I asked Dr. Brandt to come in and for a few minutes just tell the committee about his work, what he's already seen. I think you're working at the treatment plant here in Laramie. So it means a couple things. We can hopefully use that water to produce hydrogen. At the same time, we use our great coal resources. So Dr. Brandt, I'd say just tell us about your work, your research, what you've got to date. And I thank you for being here at the last minute.
Absolutely. It's a great pleasure to be here. I'm glad I'm not wearing the jackets and ties that my fellow men are. So our work here at the university through the School of Energy Resources focuses on maximizing the utilization for our benefit of what I view as our most precious resource, and that's water. And that water can be fresh water, or in this, what we tend to focus on, it can be a byproduct water or produced water from oil and gas extraction. So my main emphasis is on technology development in order to reuse, because we can always reuse water. We can do a lot of things with water. It's just how much energy, and by energy, money it's going to take to do something useful with that water. And so when people ask me, well, can we do something beneficial with produced water? Absolutely, we can. We have the technology. We can definitely do that. But can we do it economically so that it makes financial sense to do so? So I won't go through the broad spectrum of different technologies that we've developed here at the university. More recently, we've focused on how can we utilize our coal resources to make those technologies better, to make them more energy efficient and things along that nature. And that involves water treatment, but it also involves trying to replace Nafion membranes for fuel cells. And that's something where we've discovered the biggest benefit for what we get is a nanocarbon out of coal. So we have also looked extensively at what will it cost in order to treat or clean up produced waters to use it for green hydrogen production, primarily here in Wyoming. And we've done that with a number of commercial entities. And it turns out that of all the different produced water states, Texas, Oklahoma, so on, New Mexico, our produced waters are best centered from a quality perspective for us to do that economically, where they can still make money. Because really that's what it comes down to for hydrogen production. And that just has to do with the amount of salts that are present there in the water. So we have worked at not only demonstrating experimentally, but theoretically what those energy amounts or dollar amounts are going to be in order to do that. And it's good for us. It makes a lot of sense to do that. Rather than just sending it back down hole or reinjection or allowing it to evaporate, which in my opinion is a tremendous waste of a very important resource here in the state.
Okay. Quick questions for our guest while we've got him. Thank you for breaking in. Oh, go ahead.
Thank you, Mr. Chairman. Doctor, how much, what kind of salinity can you clean up, or and are you actually extracting the salts, or are you just taking the TDS out of it, or what are you doing with it?
So when it comes to salt separation, it's truly a separation process. So we concentrate the salts into one stream, and we produce a clean secondary stream, which we then use for the green hydrogen production. So here in Wyoming, we average between 10 and 30,000 milligrams per liter of salts, which is a little bit less than what you see in the seawater. So we can get anywhere from 50% to 85% recovery, which means of what's coming in, we make into a clean product that we then can use for hydrogen production. Now, historically, we viewed that other 15 to 50% as a waste, but given the emphasis on critical mineral extraction, that now represents a more mineable brine where we can get things like rare earths or lithium, depending on the formation, or other precious metals. But regardless of your operation, we still end up with something that we must, I'll say, dispose of or manage.
Okay, go ahead.
That all makes good sense. So on the heavy water side, we're talking something that's gonna be like a 9 or 10 pound brine, depending on the amount of
Yes, sir.
saltings that, or salts that were in it.
Yes, sir.
So we could use that even for heavy water.
Absolutely.
So that's a sellable product too then.
Yeah, so we've put a major emphasis with our SER team at not trying to not view anything quite honestly as a waste. There's always a use for something. It can get down to just rock salt production if you can find the right entities to partner with. It's certainly also for fracturing, for enhanced oil recovery, the higher that density goes. We can make use. The true challenge here is not a technological one. It's bringing all of these parties to work together that have expertise in these different areas for the different reuse applications.
And what's your, excuse me,
Just keep going.
what's your energy sources? Electricity or what are we doing?
Electricity. So of course, we have looked at traditional fossil fuel sources. A big source that the hydrogen folks are looking at are renewables to try and they have the push to minimize their carbon footprint. For our part, we're also looking at how we can utilize flare gas to offset the energy requirements for the desalination.
Very good.
Good. Any other questions? Thank you for joining us, sir.
Yes.
Co-chair.
Yes, Dr. Brandt, thank you very much for
Oh,
your time and taking you away from the project that you're actually talking about.
My pleasure.
Thank you. Appreciate you
Great,
coming.
thank
Okay.
you.
All right.
Okay, Director Henson, we're gonna double up on you here, bring you back for tax-free storage facilities and Severance tax processing facility division. Bring any friends you'd like to the table. Time is yours.
Mr. Chairman, Brenda Henson, Director of Department of Revenue. So you want us to move to,
Yeah, we left tax-free storage facilities. We ran out of time there. So
okay,
anything you want to touch on that? And then we'll go straight into severance tax processing because we have you back to back there.
okay. Mr. Chairman, if you'd like, I can speak real briefly to these storage
Certainly.
area.
touch on it.
Very briefly related to past legislation.
Okay. Co-chair would like to say a few things about it first.
Thank you.
Okay, thank you, Mr. Chairman. So for everyone, we've talked about this in the legislature for the last few years. Off and on, we've had a couple bills, none of them have gotten through for a variety of reasons. And currently, if you buy equipment and you store it, not knowing when you'll need it. For example, talked to one of our oil producers who said when they can get them, they will buy almost every pump jack they can find because they're hard to get, and they'll store them. Once they take delivery of them and they're in storage, they have to pay taxes. They have to pay the excise tax when they buy them, and then they have to pay the property tax when they're storing them, although they might not be installed for 3 or 4 years. And so industry has asked us to look at this of, is there something that can be done that in effect you pay the tax once it's installed? And the director and I have had a good conversation last winter about this, and well, it might still be winter. It was snowing earlier for those of you who weren't here. So I've asked the director to talk about that. She said she had some ideas on things we could do. So with that, that's the conversation.
Time is yours, Director.
Okay, and thank you, Mr. Chairman, Co-Chairman Burkhart. So, yeah, historically, there were several pieces of legislation. You may recall it somewhat initiated for wind turbines. It was wind turbines coming into the state. They were being delivered to laydown yards, and then at another time, that company then would install them somewhere else. And the discussion was around, should that equipment in a commercial storage facility be exempt from property taxation until such time that it was installed? It kind of expanded then to an energy industry exemption, so that regardless of whether it was wind turbines, anything, it actually went down through coal, oil, natural gas, wind turbines, any of those energy related types of equipment, that if it was in a laydown yard, perhaps it could be exempt. I will say that during that time, it was important to have clarifying language in that bill that it is only when they are stored in a commercial storage facility, because quite honestly, most industries have spare parts. Whether we call it spare parts, construction work in progress, some of them just call them inventory. Most of your refineries have an entire building of just spare parts. Those are all taxable under property tax. Now, are they valued as if they were installed and producing an income? No. County assessors are still bound by that fair market value requirement. And so if you have parts laying in a laydown yard or laying anywhere, obviously the value of that is not even what the person purchased it at. And so we know that those are some of those appraisal theories that county assessors are using across the state. But the key is, in any legislation that you do, if you want it to be universal to all industries, that's going to be a significant impact. But if you make this exemption specific to that equipment that's delivered to a laydown yard, a commercial laydown yard, until it's actually installed, that could be done. But I will, just one other item to note, for property tax purposes, we have one assessment date, January 1 of each year. So on January 1 of 2025, if that equipment was in a commercial laydown yard, it could be exempted if that's what the statute said. But then, of course, the next assessment date is January 1, 2026. We don't prorate anything. It's just, it's either here, has situs in Wyoming, and it's taxable, or it's not. Now, I will tell you that there are numerous situations where that equipment is dropped off, it's stored there for a few months, it then is installed where it's going to go, and it's never taxed for property tax purposes prior to installation. So we have a lot of, again, of moving parts here. But my point is just that as long as we were very specific as to exactly where that tax-free status, and you may recall some of the other history, there are other states that do have an exemption, and the part of the economic incentive here was to support our storage facilities in Wyoming, where they weren't getting the business because companies were putting that equipment in other states where there's no property tax that liability. And so, Mr. Chairman, Co-Chairman, I hope I have covered the topic.
You have any questions for the director on this topic? Apparently not. Thank you
Okay.
for the review. All right, let's transition. Oh, public comment on this. Being none, there's nobody in. Okay. Severance tax processing facility definition, switch gears.
Mr. Chairman, perhaps it would be best, I know Brian put together a summary of the litigation that was settled in the Supreme Court. And then after that summary, I would like to defer to Mr. Grenbeck.
Okay, are you comfortable talking for a moment on this, Brian?
Yep, sure
Okay.
thing, Mr. Chairman.
It's all yours, sir.
So, Mr. Chairman, members of the committee, 14-01 in the online meeting materials, you should have a memorandum also included in the paper materials on Chesapeake Operating LLC versus Department of Revenue. And maybe, Mr. Chairman, with your indulgence, just by way of background, how this came to this committee for this meeting. The Joint Judiciary Committee for several years has selected Supreme Court opinions to review when those opinions have interpreted statute or discerned legislative intent. So they have received a summary of those opinions and then decided to take action, or in some cases, take no action in response to that holding. This was a case that the Judiciary Chairman identified as one that maybe sent a little bit of a signal to the legislature. And given this committee's topic expertise, I believe, Mr. Chairman, they contacted you and the co-chairman about considering this case in minerals. What this case considers is whether an oil and gas operator's field facilities were processing facilities for purposes of calculating the fair market value of natural gas for severance taxes. There are two provisions in statute that are relevant here for how that fair market value is calculated. So first, 3914-203B2 says that expenses that are incurred by the producer before the point of valuation, i.e. anything involving production, are not deductible from severance taxes. And then 3914-203B4 talks about when the production process for natural gas is completed. And it's completed after extraction from the well, gathering, separating, injecting, and any other activity taking place before the outlet of the initial dehydrator. If there's no dehydration of the natural gas other than within a processing facility, the production is completed at the inlet of the custody transfer meter. Statute defines processing, but there is no definition in statute for processing facility, and there is no definition in the rules of the Department of Revenue for processing facility. So what has happened over the years is an operator will value the natural gas at a different point. There will be an audit, and the results of that audit are no, based on the activities that took place, you should have valued the gas at this point rather than this point. The result being generally an assessment of additional severance taxes that are due from the operator. Over the years, the Supreme Court of Wyoming has, in considering litigation involving this area, has outlined a number of principles that the court uses. These are on page 4 of your memo, to determine whether, and really in this situation, it's a question of whether a dehydrator or other facility is a processing facility. If it's processing, then it's not production and the gas is valued earlier. If the dehydrator is considered production, the gas is valued later, generally to the detriment of that producer. Mr. Chairman, the specific case itself, I don't know if I need to go into too many details about it. This was an operator who built 7 facilities to facilitate the sale of natural gas to produce. Previously, they had been flaring the natural gas. They had valued the natural gas. So these facilities they built included dehydrators. The producer valued the gas at an earlier point than the dehydrators. But the Department of Revenue and the Department of Audit determined that those facilities were production facilities, meaning that the gas would be valued not earlier, but at the point that they left those dehydrators. The producer appealed to the Supreme Court. The Supreme Court upheld the decision of, it would have been the State Board of Equalization that considered it. And most relevant here for the committee's consideration is an observation that 3914-203B4, which is included, the text is included in the memo. That's the provision that describes a processing facility. The court observed that that provision has been a bountiful source of litigation, one that is likely to continue as processing and production technologies evolve. And the court also said that the statute's failure to define processing facility makes application of that statute difficult for taxpayers, the department, and the courts. So really, I think the question, Mr. Chairman, before the committee is whether the severance tax statutes should define processing facility. And if so, what that definition should be, or if so, whether that definition should be left to rule of the department. And of course, another option for the committee is no action. The court has, through a number of different cases, has outlined the principles that it uses to determine just what is and isn't production and what is and isn't processing for determining where the point of valuation for the natural gas. With that, Mr. Chairman, I stand for questions.
Questions, Brian?
Question.
Go ahead.
Thank you, Mr. Chairman. Mr. Fuller, do the feds differentiate from what the state does as far as where that point of custody is?
Brian?
Yeah, Mr. Chairman, Senator Cooper, I'd have to look that up. I don't know that off the top.
Further questions? Okay, thank you, Brian. Good summary. Back to you, Director. Oh, and on.
Good afternoon, Mr. Chairman, members of the committee. Instead of delving into all the ins and outs, the legal arguments of this case and the others revolving around what qualifies as a processing facility or what doesn't, I'll just try to give you a whole perspective from the department's view. Excuse me. This Chesapeake case is certainly not the only one. There's been quite a number of cases revolving around the definition of what is and what isn't a processing facility. And I just want to dispel the notion that all of these cases have introduced complexity. No, what have we got? What have we received from all of this? Far more concrete decisions and decision trees on what is and what isn't a processing facility. This isn't only applicable to Chesapeake, it is applicable in all the coal bed methane cases we had, and there's another large producer who has a huge facility in southwestern Wyoming. In all of these cases, I want to dispel a couple of notions that have been presented. One is that it's difficult for the department to interpret the statutes regarding where the point of valuation is relative to processing facility. In every one of these cases, everyone that has gone to the State Board of Equalization level, the department's position has prevailed at that level. In all of these cases, other than one at the Supreme Court, the department's position has prevailed. So it hasn't been difficult to administer the interpretation of the statutes. It's just been difficult to convince the parties involved that the department's right. Furthermore, through all these decisions, we have enclosed, somewhat encapsulated what is and what isn't a processing facility. From the department's situation, we're concerned that changing or introducing processing facility as a definition may render irrelevant or useless all of the litigation that we've gone through before. And in effect, changes the intent of the original statutes. That's our biggest concern. Just to follow up on the fact that the department's position has prevailed in nearly every case, in my mind, proves that the department's interpretations haven't been onerous, they haven't been abusive. You know, we've followed it, it's applied uniformly, and it isn't a matter of overturning, you know, reckless decisions by the Department of Revenue.
Okay, Director?
And in closing, if I may follow up, I think that some of the discussion, one of the things you heard was a changing technology, changing processes. So the guidelines we believe that we have are better than trying to define it. I hate to compare it, but in my position I've heard, you know ag land when you see it. But define it. You know a processing facility when you see it, but define it. I think that the litigation that we've had through the years, going through all of these unique properties, provides sufficient guidance. Certainly, if it's the will of the legislature that it be defined somehow statutorily. We have not done it in rules because we just don't think that that broad brush would do nor the department nor the taxpayer a benefit. So that's our 2 cents.
We can ask. Yeah, go ahead. Committee, any question? Go ahead.
Thank you, Mr. Chairman. Just a question. I want to be clear on the department's position. Is it your position that you do have the rulemaking authority to add that definition if you wanted to? You just haven't.
Okay, go ahead.
Mr. Chairman, Senator Ellis, that's correct.
Follow up, Mr. Chairman. Just trying to think about, being in a position where you're trying to, assess whether or not you need to pay certain taxes or not. I'm sympathetic to wanting some clear rules and a clear definition. I think at the federal level, we see this all the time with federal agencies where they put out guidance. And there's always that question of how binding is guidance. It's guidance. It wasn't developed through a rulemaking process. So I understand where your position is. Well, we don't want to define it and put some parameters around it. But from the other side, that's what's leading to continued litigation. So how do you resolve like that concern and that argument?
Director.
Go ahead.
Mr. Chairman, Senator Ellis, there is a provision in the statutes that allow any taxpayer to come before us and present their situation and give them a ruling. We have to give them a ruling which they can appeal at that time. And in a number of these situations, it wasn't determined after the audit. What was known, and the taxpayer decided to report it in the way that they determined the statute should be interpreted. And that's where the additional tax came in, because they did not want to follow the advice and the ruling given by the department.
Good, Senator.
Just a follow-up.
Go ahead.
I think that's the crux of the whole problem, right? Is how binding is your guidance? And if you're looking to get a different outcome, or as you say, they don't like the definition, I would do that too. So I think either between your agency or us, there is some value in talking about, because the goal would be for clarity and reducing the need for litigation, right? That's a responsibility I think that we're all keenly aware of that we have and can help resolve. So again, your thoughts on that statement.
Senator, let me interject. Are you suggesting we initiate something then legislatively?
No, Mr. Chairman, I just want to see the goal, and I guess maybe it's a question for everyone, is do we want to see reductions in litigation, or if we try and come up with a definition, are we just increasing opportunities for litigation? I'm just pushing a little bit on some of the assertions that were made by our presenters.
Endless topic, but we'll let you come back and address it. Fine.
Mr. Chairman, Senator Ellis, so yes, this was recent litigation. But prior to that, it's been approximately 7 years since we had any litigation with this. And I think the exploration of the litigation that we have had will show the diverse nature of this topic and why it's better to have multiple benchmarks that are applicable to the technology of the time than it is to put some words together. Now, I will say that the way the rule promulgation goes is if there are companies, persons that wish the Department of Revenue to promulgate rules, they have the opportunity to request that. And we have not had that request.
Okay, fair enough. Go ahead.
Mr. Chairman, if I may add one more comment regarding some of the comments we're hearing too about the new technology. What was going on in the Chesapeake case were pieces of equipment that were clearly delineated as production related, but basically the litigant said, well, we've thrown a chain link fence around all of these, and now all of a sudden it makes it a processing facility. The point here is it's not new technology. Separators, compressors, and dehydrators are as old as natural gas. Now they've updated, the capabilities of those devices, but these are the same devices since natural gas has been instituted. It's just a matter of wanting to torture and contort the statutes to get a transmogrified version of what a processing facility is. That's the department's angry response and all that.
I told you, Mr. Chairman, he was going to be honest today.
Yeah. Suggest, okay, let's do this. Because we can kind of get into something that wouldn't stop. Let's go ahead and if there's no further comment from committee members, let's check with those in the room. No? Okay. All right, nothing. Okay. Committee, is there anything that you desire to do with this at this point other than the report? Mr. Co-Chair, do you want to weigh in?
Thank you, Mr. Chairman. I can see both sides of this, and I can think of some specific examples. I rolled this around in my head, and as the director said, yeah, I know processing facility when I see it. Other people might not. However, on the other side, I like definite rules. If we're talking about taxing people, I want to know what the rules are going in. So I think it's something we maybe need to look at between now and the next committee meeting. All of us give it some thought. If that makes any sense. I know that the department would be glad to work on it with us on it. I don't want to put more statutes in the books if we don't need to. But at the same time, I think industry would like to know some very specifics. So I know that's as confusing as the discussion we just had. If that sounds reasonable.
Nothing more other? Okay. All right. Committee, any other desires with this before we close out? There being none. Let's move on. You got this in your file. You've been sent it to the next Senate file. Brian, you'll take care of this sales and use tax amortization. This would be Senate file 61. Brian, are you going to explain this?
Yep, Mr. Chairman, members of the committee, this is 15-01 in the online meeting materials. This was a topic identified during the committee's interim topic meetings as one for consideration. Again, Senate File 61 was a bill that this committee sponsored in the 2021 general session. And I won't go through it unless there is a desire to, Mr. Chairman. I won't go through it line by line, but just hit kind of the broad strokes of what this bill.
Do that unless somebody wants a line by liner. Go ahead.
Yep. So, Mr. Chairman, this bill would have authorized the amortization of sales and use taxes for certain specified projects. The projects that would have qualified for this amortization of sales and use taxes were those that over the first 2 years of construction or operation would have had expenditures exceeding $5 million. If that was the case, then the taxpayer could apply to the Department of Revenue to amortize a portion of the sales and use taxes. The department would have been required under the bill to develop amortization schedules, certain rates, terms, fees, and payment schedules. The department would have entered into an agreement with the taxpayer for the amortization of these taxes. Probably, Mr. Chairman, the last key point I would note, the amortization is only available for the portion of sales taxes that are distributed to the Department of Revenue, the 1% for the administration of sales tax, and then the portion, I believe, 69% of the sales tax that's distributed to the general fund. It would not have permitted the amortization of any sales taxes that are distributed anywhere else, local governments, for example. If you amortize the property that the sales tax was paid for, would have a first priority lien placed on it during the period that the amortized taxes are paid. That's a pretty brief overview in a nutshell, Mr. Chairman. Happy to answer further questions.
Questions on the bill, Brian's work? There being none,
Mr. Chairman.
go ahead.
So not necessarily a question for Brian. This is something the committee has looked at over the years, and with some very large projects, power line project, $1 billion project, right up front, you'd be owed $60 million in sales tax, excise tax on that equipment. So the idea was to give companies the opportunity to amortize that over a period of time. And I think the controls were there. I know Senator Rothfuss and I have worked on this and thought about this for quite a while, and I'll let the good senator chime in here with his thoughts, but I think it's something we do need to consider. We've talked about tax reductions, we've talked about exemptions and that. This is one where it's neither reduction or exemption. We allow large projects to pay that tax over time rather than upfront.
Senator Rothfuss, you want to weigh in?
Yeah, thank you, Mr. Chairman. And I agree with Co-Chairman Burkhart. We spent some time on this. There were some challenges, and in fact, there is a later draft that didn't end up getting released that Mr. Fuller worked on to try and improve on some of the challenges. But one was the idea that some cities and counties were actually interested in being able to amortize their local portion, so providing flexibility as to whether or not you could do the entirety of the sales and use taxes and how that might work to provide flexibility for projects. That was an interest that was looked at. Another was the scaling of the projects and what types of projects might be eligible. There was some concerns about how the lien was structured and what surety would be in place based on the project type. So there were some concerns that were raised, and I think when we ran this the first time, it did pass out of the Senate, and I think it was held in Minerals Committee over on the House side based on some of these concerns. If I'm not mistaken, we just needed to take another look at it and do some more work on it. So I know that there was tremendous interest from some industries as well to see this done, because from their perspective, it was changing from having to finance the sales and use tax on the front end to being able to cash flow the sales and use tax through the operation of the project. And that did tend to significantly change the financials of a project, where from the state's perspective, it really doesn't change things all that much, just the schedule of when we'd get the funds. And for large projects, there was even some interest in ensuring that rather than having all the funds come in at once, having them come in staggered over a period of time was even preferential in some ways from a policy standpoint. And there was a low interest rate as well that went along with that to ensure that the state was made whole. So it's a good opportunity to not necessarily provide a tax cut, but to provide flexibility on the payment structure so that while the same tax revenue is coming to the state, it's coming in a way that is more financially practical for the developer. And if we can find a way to solve the problems that we did here a couple of years ago, I think it would be beneficial for development.
Any questions for either Senator Rothfuss or Representative Burkhart from the committee? Okay. Brian, did you want to add anything else to it as far as, okay. All right, let's go ahead then and move to public comment on it. There being none, anybody online? It's committee's desire. Mr. Co-Chair.
Mr. Chairman, I would move that we have a draft written to look at this again, probably based on previous Senate File 61 from 2021, and the draft that was prepared that Senator Dockstader and I worked on, or not, I'm sorry, Senator Rothfuss and I worked on since 2021 to at least have a discussion available for the committee. And if I can get a second,
Is there a second for this?
Second.
They moved and seconded. Do you got
Okay.
a second?
So with that, as Senator Rothfuss said, it gives companies some leeway and some incentive. Recently, the last few years, we've been seeing more and more projects that are $1 billion or more, and they continue to grow. We have some coming online that could be as much as $6 to $8 billion. And at $8 billion, a company would have to come up with $480 million initially just to pay that excise tax. And I think they should be allowed to amortize that over time. They would have to borrow the money to do that. It doesn't really affect their cash flow and their financials. In the long run, it kind of stabilizes some of our tax structure in that we get the money over time rather than a big lump sum that then somebody's going to want to do things with. So that's my logic.
Any further discussion? Mr. Chair. Let's go Senator Rothfuss and then Representative Larson.
Thanks, Mr. Chairman. I think this might be a good bill also to put together a little working group on we've done that in the past for some legislation over the last few years, and I think that's an effective way for us to get to a good outcome. There were enough issues under discussion on this particular piece of legislation that having a little working group and then getting some testimony from stakeholders that have concerns so that we can bring back a bill that's mostly ready for the next committee meeting would be something that the chairs might want to consider. It's certainly something I'd be happy to serve on.
Hold the thought on the working group. We'll come back to that. Representative Larson.
Thank you, Mr. Chairman. So I'm just curious from the people that were in the legislature when this was brought back in 2021. Did you have any discussions on how this may impact industrial siding money? Because that is the state portion of the sales and use tax.
Remember, Mr. Co-Chair?
Mr. Chairman, I don't remember exact conversations, but it's my recollection that it doesn't directly impact it. It's the excise tax that is due on the materials on these large projects.
Anybody want to reflect on 2021? Not mixture of new and old. Let's go back to Senator Rothfuss's suggestion for a working group. I'd like to hear your thought, Mr. Co-Chair.
Thank you, Mr. Chairman. And I can heartily agree with Senator Rothfuss to look at those issues that did come up. I was not chairing minerals at that time, and I can't remember exactly why it kind of got stuck in House Minerals. It did pass House the Senate and that. So I think we can go back and look at those records and see what happened and put a working group together. And because Senator Rothfuss and I have worked on this so long, I'll obviously volunteer to
So it'd
work
be,
with him and
the way I
others.
see it'd be you, Mr. Co-Chair, Senator Rothfuss. Would I have two other volunteers? Okay, one, two.
Yeah, well, maybe we want two senators, two representatives,
So you're
Mr. Chairman.
expanding the workload now. Okay. Any senators want to?
Mr. Chairman, I guess the senators are bright enough to not volunteer. Okay, we have our committee.
Okay,
I do have a question.
go ahead.
Should we be considering what kind of effect this has as far as implementation by the Department of Revenue? And with this working,
Well, the working group, as I see it, can answer that, but Co-Chair?
That was going to be my comment. We would include them in the discussions also.
Go ahead, Senator Rothfuss.
Thanks. And there was interest by cities and counties to try and figure out whether they could be engaging their local, both the local portion as well as the optional portions, how we would have to structure changes to make it optional for them. That was what we were discussing before. And I don't think we'd quite threaded the needle on how to get that done, to have language that would allow that local option if they chose to allow it. Again, that not being up to the state at that point, but being a local opt-in if they would choose to amortize. So making sure that we had engagement from county and city, like whether it's WAM and County Commissioners Association, for example. I think that those would be others to bring in for stakeholders, but we can put together that group.
It's a
I think
working
everybody
group.
knows who wants to be involved.
It's a working group. You can reach out to those folks.
And Mr. Chairman, the executive director of the County Commissioners Association is sitting here nodding his
Yeah.
head. So
I think he worked on it.
yes, yes,
I'm
he-
not
my
mistaken.
recollection is he did.
Okay.
Uh,
Make sure he gets the calendar note.
Yeah.
All right.
Okay.
Anything else with this? Let's double check in the room. Anybody else in the room? Or the Zoom? Okay, let's we've got a working group with this. And you're going to develop a bill that you can bring back.
Yes, Mr. Chairman. Mr. Chairman, I did make a motion. Do we need to vote on
Oh,
that?
sure,
motion?
yeah. Moved and seconded. All those in favor say aye.
Aye.
Those opposed, nay. There you go. Working group, go and do good things. Department of Environmental Quality, we have some people stepping in for Mr. Parfit. Brian, do you want to go over Senate File 44, limited mining operations first? Didn't you bring some friends? Thank you. There you go.
Yep, Mr. Chairman, I
Okay,
can do
go-
that.
Go ahead and do that
And
and we'll get the right people up to the table here.
all right, Mr. Chairman, members of the committee, 25 LSO 0001, limited mining operation amendments. You should have working draft 0.3. This is 16 -01 in the online meeting materials. This is based on 2024 Senate File 44, which the committee sponsored last year and was enacted by the legislature before being vetoed by the governor. This bill draft would amend requirements for the commencement of limited mining operations, amend and update bonding notice and reporting requirements, amend bond release provisions and extension requirements. So, Mr. Chairman, since this one, my understanding from you and the co-chairman is that, there may be interest in sponsoring this at this meeting. With that in mind, unless there's objection, I will go kind of page by page through this draft.
Objection, let's take it through it.
Yep. So, Mr. Chairman, beginning on page 2, line 10, in 3511 401 E6 intro, this is the paragraph concerning limited mining operations. Instead of listing specific minerals that are under this exception to the requirements of the article on land quality, instead of listing the minerals, it would be a reference to any non-coal mineral except those minerals that the Nuclear Regulatory Commission regulates and those for which the nuclear related minerals that the state has assumed a primary regulatory authority. On page 3, line 14, this is the beginning of the subparagraph concerning bonding requirements for these limited mining operations. For this, there is on page 3, line 14, the inclusion of specific materials that are listed. Then page 3, line 18, this was an amendment that was adopted during the session to basically grandfather in at the $2,000 per acre bonding requirement for existing limited mining operations before July 1, and in this case, it'd be 2025. And then it would increase to up to $5,000 an acre for operations on and after July 1, 2025. Page 4, line 1 is the same concept for quarries. So that existing $3,000 per acre amount would be before July 1, 2025. And then page 4, line 2 increases that to $7,000 per acre for those operations commencing on and after July 1, 2025. Also specifies on page 3, line 5, or page 4, excuse me, line 5, a full cost bond may be filed to ensure reclamation and all other non-coal. So if that material is not listed on page 3, all other non-coal limited mining operations is required to file a full cost bond. Page 4, line 9 changes the time in which the Department of Environmental Quality could amend or require the posting of an additional bond amount. It changes that deadline from 90 days to 150 days after commencement of limited mining operations. And then page 4, lines 14 and 15 extends the period that an operator would have to post that additional bond amount from 30 days to 45 days. Mr. Chairman, the staff comment on page 4 and going on to page 5 is the same language that was on pages 3 and 4. This is just structured, I think, in a way that will make it clearer to understand what bond is required for what type of project. So it's the same language. It just breaks that language up, I think, in a more user-friendly and readable approach. And I'm happy to answer specific questions on that.
Let's check. Keep going.
Okay. Mr. Chairman, page 6, lines 3 to 5. After the cessation of limited mining operations, the operator would be required to notify the land quality administrator of that fact and plan for the commencement of reclamation within 45 days instead of currently the notification would be in the next annual report. Page 6, line 11, this is subparagraph D. Immediate reclamation is not required for limited mining operations for the removal of any non-coal mineral except those nuclear-related minerals. Page 7, lines 3 and 4 is a conforming amendment. Then page 7, line 19, mining operations that are authorized and approved under this subsection. These are for limited overburden surface operations before July 1, 2025 are authorized to continue. This language, starting at the bottom of page 7 on the top of page 8, specifies that on and after July 1, 2025, no further applications for these types of operations can be approved. Page 8, line 10, this is an amendment to the section concerning the annual report for limited mining operations. And just requires the operator to list the number of yards or tons of minerals sold during the past year. Page 8, line 14, if an operator is requesting a renewal to continue limited mining operations for an additional 5 years, there must be evidence that the limited mining operations will continue that include the following. And then page 8, line 20, going through most of page 9 are the list of the types of evidence that could be submitted in support of that requirement. So a mineral supply contract within the renewal period, a government project in the area that's scheduled to begin, a major industrial project, evidence that operations are active and have commercial sales within the last approval period, evidence that a valid surface and mineral owner consent contract or lease extends into that renewal term, evidence that site is under reclamation, or any other evidence specified by rule of the department. Moving on to page 10, this concerns the release of bonding. And so for limited mining operations, the administrator may, and this next part was an amendment during session in the Senate, after consultation with any affected surface owner, recommend the release of the bond after 2 successful growing seasons that establish permanent vegetative cover. Page 10, line 22, this concerns the release of bonds. So the bond may, after any consultation with any affected surface owner, as another Senate amendment, may be released after that 2 successful growing season with permanent vegetative cover. Page 11, section 2 is rulemaking, and then it would be a split effective date for the rulemaking similar to last year's bill. With that, Mr. Chairman, I'd stand for questions.
Questions? Keep going, Brian. That's it. Okay. Nothing else. With that, let's turn it over to those filling in for Director Parfit. Go ahead and either one of you gentlemen first. Just
Yeah, well,
try to
thank you,
identify
Mr.
yourself.
Chairman. Again, I'm Alan Edwards. I'm the Deputy Director for the department. With me is Administrator Wetland, who worked this bill extensively this last session as well. So I would like to defer and turn it over to him for comment and answering
Fair enough,
questions.
sir. You did put work into it. Go ahead.
Mr. Chairman, I only really have one comment. I think Brian's done an excellent job, getting the bill back to its original form. And then also in the bonding section, the staff comment, I'm in support of that concept of splitting it out. I would have 2 adds to that if that's a direction the committee goes.
Go ahead.
And I have pointed those out with Mr. Fuller. In page 5, line 7, after per acre, I would add of affected land, including roads used to access the mining operation. I would make that very same edit to page 5, line 11. That way we're consistent across the board with any of these operations that the access road is not included in the 15 acres, but the access road is bonded for reclamation. That's what it does. And I would certainly support that. In the event that the committee would desire to stay with its original language, I would suggest on page 4, line 5, changing after July 1, 2025 period of full cost bond to after July 1, 2025, comma, or a full cost bond, because that's what we were trying to do, is give the operators an option to post the per acre bond or a full cost bond. But I really would recommend and steer the committee to the revised staff recommended language on the bonding. I think that is much clearer path.
Okay, that's rather than this handout, is what you're saying?
Mr. Chairman, the staff comment is in the draft bill, and then my handout would be the add of that language
Okay,
on the access roads.
fair enough. Everybody has a copy of the handout, right?
Mr. Chairman?
Go ahead.
Mr. Chairman, I just want to be sure that that's as clear as we want it to be, because we're just talked about ambiguity in our statutes. I mean, if we start saying the road, I just want to make sure we're clear that that's not calculated in the acreage. And I know you said that, but I'm just reading it in there and I don't know that that's crystal clear to me. Is there a way to strengthen that language?
Yeah, to you first, but for Brian, your thoughts on that language?
Yeah, Mr. Chairman, Senator Ellis, do you mean the proposed addition from the department?
Correct, Mr. Chairman.
Yeah. So, Mr. Chairman, Senator Ellis, I mean, the existing language, I think does, on the bottom of page 3, it does reference including roads used to access the mining operation. You know, I'm not sure how this has been interpreted, you know, previously. Certainly including it in the language, you know, whether that would change an interpretation or not. You know, I would, you know, the department applies this, the department promulgates rules based on this. You know, I'm hard pressed to say, you know, whether there'd be a change or not. I mean, the language, it is all kind of put together. You know, and there is a, you know, a comma that would suggest, you know, maybe how that should be interpreted currently. I can't speak to how it actually is being applied, though.
Okay, let's come back to you, sir.
Mr. Chairman, how it's being applied is it's 15 acres is the LMO maximum disturbance limit, less the access roads. And the reason that was done, that was changed in 2014, was because we had companies developing roads around other property boundaries and really
Understood.
incurring additional disturbance that was unnecessary. So the decision at that point in time was to limit the acreage change went from 10 to 15 acres and then excluded the access roads from that 15 acres, but still bonded for those roads. And that is the department's interpretation at this point in time.
Senator Ellis?
Thank you, Mr. Chairman. I think I see it. It's on page 2. Thank you.
Comfortable? Okay, good. Anybody else? Senator Rothfuss?
Thank you, Mr. Chairman. Mr. Chairman, I want to chat about the J paragraph on page 7, which effectively removes the small mining operation consideration. And, you know, we worked this bill last year and there ended up being a lot of consternation around the elimination of small mining. And I guess I'd just like to revisit the motivation of the J paragraph where the key provision is obviously at the bottom, which terminates the functionality of the J paragraph after July 1st, 2025. Why do we need to terminate that option, which sounds like it is the source of consternation with this particular legislation? I don't think anything else in the legislation has caused any heartburn for those that have really read the whole bill and understand what it does. So what's the purpose of that J paragraph being in there? And what would happen if it weren't there?
Let's get your thoughts on this, gentlemen.
Yeah, Mr. Chairman, it's pretty straightforward. We looked at the small mine operations and there's a limit on overburden yardage and annual tonnage that can be produced. And those limits are just simply inadequate. We're seeing a lot of operators because the highway jobs and stuff are increasing to where they're just going beyond those limits because they have to. And the only difference between the small mine and the large mine is really in the reclamation performance standards. In the small mine, you do an ocular walkthrough for the reclamation. In the large mine, you actually do a few statistics and have a little bit more thorough demonstration of the adequacy of the reclamation. Outside of that, as far as any baseline requirements, bonding requirements, they are the same. So it raised the question as to why do we really need to continue to have the small mine moving forward? And there was consensus in our discussions with industry that it's, you know, it streamlines things really for the agency and actually clarifies the the process of going from exploration to full development by just going to the large mine permit.
Follow up?
Fair enough. Go ahead, Senator.
So to make sure that I'm understanding it, it does not remove in any way this elimination of J by the new language. Wouldn't remove any obligations for a mine of this small size. It just wouldn't be governed by the small mining operation. It would now be governed by the large mining obligation. So there's no current or potentially proposed small mining operation that would be exempted under any circumstance as a result of this language. It would have the same rigor, but they would just be working through the large mining operation and would not ever have to do a transition.
Mr. Chairman, that's correct. And that was really part of the regulatory reduction here in the process of the thought process of modifying the language.
Mr. Chairman, one other line.
Senator?
What about the possibility of going from a limited mining operation? So I'm very small, I'm down below 15. And now I decide I want to turn this into a mining operation. Can you walk through with this new language? I'm now scaling up. How would that proceed?
Is that possible, sir?
Yeah, Mr. Chairman, you would have to go through all of the baseline requirements of a large mine and then go through the application and completeness review, the technical review, and then also the full-blown public notice process and comment process and potential appeal process. Small mines today have to do that as well. So there's really no difference there.
Okay,
And one more question, Mr. Chairman.
okay, go ahead.
Is there anything in this bill that changes what would or would not qualify as a limited mining operation, or that changes anything that would or would not qualify as a mining operation? So it seems to me that it stays effectively the same what qualifies, and it's effectively just bonding that changes, or over on the mining operation side, whether you're calling yourself a small mine or a large
Let's
mine.
double
Is that
check.
accurate?
Let's double check what qualifies. Go ahead.
Yeah, Mr. Chairman, that's accurate. Maybe another way to state that would be I'm just going to leave it. I think you had the simplest explanation there,
Right.
Mr. Chairman.
So, Mr. Chairman, so we've had a lot of concern about this legislation, even for this particular meeting, and I think the concern doesn't align with the legislation, what the legislation actually does. The concerns might be valid concerns, and I actually share
You
some of
want to
them.
bring an amendment?
No, I just wanted to make sure that I'm
Okay.
not
Oh, I
missing
see.
something in the bill.
And we had a lot of fun with this one.
Yeah. So
Yeah.
thank you, Mr. Chairman.
Mr. Chairman, maybe if I could, really what the bill does, it expands it to all non-coal except radionuclides. That's from the aggregate market to all non-coal, with the exception of the radionuclides. It updates the bonding provisions, which is a big thing, I think there's been universal agreement on that. And then it takes out the small mine permit because it really doesn't work anymore. It doesn't function in our system anymore. So it streamlines that process. And then it also sets up a scenario for a very clear path for an operator to go from exploration to maybe a small prove up to a full-blown mine.
Fair enough.
Maybe that helps, Mr. Chairman.
We're there. Folks, anything else on this one? Okay.
Mr. Chairman, just one thing, as always, the department stands ready to work with the committee and answer any questions and provide information as you may find
Appreciate that.
helpful.
You've been working very hard on this. Mr. Co-Chair, do you want to run it through as a motion? What would you like to do?
Okay.
Oh, go ahead.
Public
Oh,
comment.
yeah, I keep forgetting about the good old public. Okay. Anybody in the room? Anybody online? Yes, we do. Very good. Oh, we got two. Ladies first, go ahead. It's all yours.
Good afternoon, Mr. Chairman, members of the committee. My name is Kelly Little. I'm with the Associated General Contractors of Wyoming. AGC supported this legislation during the last interim and the last session, and we continue to support the legislation as written today. We think that it's been perfected over the last, the changes that were made and incorporated in this version are good. And we were disappointed with the veto of the legislation, but we understand that it's just an opportunity to perfect it a little bit more. And so we're here to speak in support of the legislation as it is today.
Thank you. Questions? Comments? Okay, committee. Thank you for taking the time. Mr. Detai.
Thank you, Mr. Chairman. Travis Detai with the Wyoming Mining Association, also in support of the bill. And our interest lies in opening it up to the non-coal mineral sector. And I think Mr. Wentland it stated it perfectly. It'll give an operator a chance to start doing some exploration to prove up and then roll right into the mining permit with the full public comment period. We think this is a good bill and had a lot of fun with it last year and hope we can have some more fun with it this year.
I hope not as much fun. Thank you.
Real
Any
fun.
questions from Mr. Detai? Okay, thank you, both of you, for coming. And I did see somebody online for a moment there.
Mr. Chairman, we have 3 online. First up was Shannon Anderson.
Ms. Anderson, go ahead. Can you hear us?
Yes, I can. Can you hear me okay, Mr. Chairman?
Yes. Yeah, go
Okay.
ahead. Thank you for joining us.
Thank you. Good afternoon, Mr. Chairman. Shannon Anderson on behalf of Powder River Basin Resource Council. First off, as we said to you during the legislative session, we want to recognize that there are some pieces of this proposed bill that we support. We appreciate the DEQ's proposed improvements to the bonding provisions of the LMO statute. As DEQ has highlighted before, there have been bond forfeitures that have ran short for past sand and gravel LMOs, and we certainly don't want that to continue to be a problem for the state. However, if that is the problem that you want to solve, we would ask that you limit the bill to the bonding sections only. Because unfortunately, the proposed bonding reforms highlight the problem with bringing in new mine types into the LMO permit exemption process. LMOs are not regulated as mining permits. They are exemptions to mining permit requirements. And skipping straight to a permit exemption process for types of mines that have never been permitted and developed in Wyoming before, such as rare earth elements, lithium, gold, copper, is a cause for concern. These new mine types are likely to bring new mining methods that will be controversial with questions from neighbors and the public about environmental impacts. Industry has not pointed to any issues with receiving a small mine permit, and that process is currently available under the statute, as you've been discussing today. It is still significantly streamlined compared to a regular mine permit process. But one of the important differences with LMOs is a small mine permit still has public comment requirements. We know public comment opportunities serve to mitigate conflict by allowing neighbors to proposed operations the ability to ask questions or raise concerns, most of which get answered by the DEQ and the company during the process. LMOs don't allow for any public participation, so here neighbors to propose mines get a notice, but they can't do anything about it. Some companies are willing to meet directly with the neighbors, and our organization has facilitated such meetings in the past, but the role of the DEQ is absent. Public participation is a core component of the Environmental Quality Act because we know public comment makes agency decisions better. Since they are an exemption to a permit and not actually a permit, LMO forms filed with DEQ do not have baseline water or vegetation sampling requirements, and they exempt these operations from most of the performance standards required of other mining operations. All DEQ has is the LMO form, a bond, and the very simple language in the statute and its LMO regulations. As we talked about this past year, LMOs were designed to facilitate short-term, time-sensitive mining projects, like for instance, a YDOT gravel pit that needs to be up and running for the summer construction season. LMOs were never contemplated to replace mine permitting requirements for other mine types that in some cases may last for decades, given the ebb and flow of global commodity prices for most minerals. Proponents of the bill argue that landowners should have the right to approve new mining on their land, but those private property rights must be balanced with the public's interest in protecting our natural resources. What's worse, some of these new mine types are proposed on state lands, including a proposed rare earth minerals mine in Johnson County in the Southern Bighorns. Waiving mine permit requirements is not the right thing to do. Rather, we should have a permitting process that ensures resources are protected on our state lands and that allows the public to weigh in on how state lands are developed. And since you talked taxes for most of the day, I would highlight that these new mineral types fall under the general state severance tax rate of 2%, and any federal minerals that are mined do not have royalty payments under the 1872 mining law. We would urge you to think about that limited revenue to ensure we are balancing any benefits and burdens of new mine types. And for these reasons, we would urge you to vote against Senate File 44. Thank you for your time and consideration this afternoon.
Thank you. And earlier in your comments, you said to focus on the bonding more or less. Would you highlight that again?
Yeah, Mr. Chairman, that's right. I think, there have been some bond issues for sand and gravel mines, which are currently authorized under the LMO statute. And we do agree with the DEQ that those bond amounts should be increased. Again, what we disagree with and what we really caution you against is expanding LMOs to additional mine types. Again, we don't want to perpetuate the problem that already exists with inadequate bonding and inadequate enforcement authority on the part of the department to new mine types that have never occurred in Wyoming before.
Okay, thank you. Any comments or questions for Ms. Anderson? Not so. Thank you. Appreciate you joining us.
Thank you.
Okay. Up next.
Mr. Chairman, we have Era Aranow next.
Hello, Erin, can you hear us?
Yes, thank you. Mr. Chairman, members of the
Proceed,
committee.
please.
Era Arano, Wyoming Outdoor Council. I wish I could have joined you in person, but appreciate the ability for remote testimony. We agree with the previous speaker. Though we support the bonding changes, we oppose this bill because of the expansion of materials that would fall under LMOs. We're concerned about the public comment and environmental consequences of expanding the types of LMOs. The presence of substantial disturbance next door clearly affects a neighbor's property value, operations on their land, not to mention their quality of life. And expanding these types of mines increases the likelihood of a mine next door. The current small mine permit process allows neighboring landowners a thorough understanding of the mine plan because details are required. With these details, they can express valid concerns and work together with the operator to potentially modify operations when feasible to accommodate these. This is a potential win for all. Not only is public comment part of the small mine permitting process, it can be meaningful because of this detailed information that's required, something that the paperwork for an LMO exemption does not require. This bill does expand the materials that can be recovered with the LMO exemption: rare earths, gold, any mining operation that can be associated with heavy metals or acid drainage has serious potential for groundwater pollution and contamination. The potential for these pollutants is site specific, and without any information from the operator, because there is no permit, it will not be possible to appropriately assess the risks. Yes, there is a stormwater permit required, but that's more focused on surface water. The environmental consequences and cost of cleanup of acid drainage or heavy metals, both in surface and groundwater, are too great for these minerals to be included in the LMO. Even the inert minerals currently exempted under LMOs, sand, gravel, etc., can impact air and water quality as well as quantity. You've no doubt heard these concerns from folks in the Casper area. Expanding LMOs expands the potential impacts to include specific pollution concerns on top of the already significant impacts. I think the current LMO process should be re-examined and not expanded. Thank you for your time.
Thank you. Questions or comments from Ms. Arano? There being none, thank you for joining us. Appreciate it. We had one more.
Mr. Chairman, we have Carrie Egan next.
Carrie, are you there?
Yes, I'm here. Can you hear me?
Audio
Hello?
only, I guess. Is that correct?
Oh,
Yeah,
I'm
we've got
sorry.
you on audio only. Is that what you were planning?
I'm sorry.
There
There
you
we go.
go.
Video.
All right, now
Okay.
we've got you.
Thank you.
Okay, go ahead and state
I'm
your name.
Carrie.
Proceed.
Yes. thank you. I'm Carrie Agin, a geoscientist and retired geologist from the Bureau of Land Management here in Buffalo. I have several questions, and it's going to be kind of all over the place because I jotted things down as folks were covering things. So my first one is, what is the difference between
You
what's
want,
called a mining?
let's do this. Let's put your questions out. Do you want to, should we bring, either you two gentlemen back up? Let's do that. Let's have you, can you deliver those questions all at once?
I believe so. I'll give it a shot.
Okay, I got them back at the table. Go ahead and give them, because some of them may tie in with each other. Go ahead and ask the questions, and I've got
Okay.
these gentlemen back at the table. Go ahead.
Okay, thank you, Chairman. My first one is, what is the difference between a mining operation and a quarry? Is it the use or potential use of explosives? When I worked for the Bureau of Land Management, there were some surface owners, like for sand and gravel operations, that did not want the soil replaced and vegetation replaced because they wanted to put up a building or a corral, something like that. So I'm wondering, how is that handled with regard to?
Okay. Let's
wanna-
take two.
sorry.
Let's take two. Go ahead. Let's take two. Go ahead, gentlemen.
Mr. Chairman, when you look at a standard operation, it's loose material, it's loose dig. Quarry is where you have a hard face. Probably the best example I can give anybody that's in the room, and you've probably driven by the Martin Marietta facility west of Cheyenne. They're in a hard Sherman granite face and they're shooting and drilling. That's a quarry operation.
Well,
And as far as the landowner question, landowners in the bill are addressed. They have a right to look at an alternative plan if they choose to, if it's private land.
okay, fair enough. Continue, please.
Great, thank you very much. Now, with regard to limiting small mining operations, I'm concerned that this may forcing them to go to the LMO, and I understand all the issues involved there, that's probably a good thing to do, but I'm concerned that it may strand valuable minerals because of the increased costs. And it was my understanding, and it's been several years since I've worked for the BLM, so several years that I haven't been familiar with DEQ reclamation costs, calculated reclamation costs. But are the SMOs up to the same vegetative and reclamation standards as the LMOs?
Okay, let's let you answer that.
Mr. Chairman, small mines and large mines are under the same recontouring and seeding requirements and soiling requirements. The only difference is, like I indicated in my earlier testimony, was when you get to the final approval of the reclamation, one is a walkthrough, one has some statistics behind it.
Fair enough. Next question, please.
Okay, so sorry, part of that question also was my concern that limiting the SMOs may strand valuable minerals because of the increased bonding costs. That's not really a question, I guess. Under page 8 through, sorry, Chairman.
Go ahead.
Okay,
Go ahead with your next question. Yeah.
Oh, great, thank you. Pages 8 and 9, subsection KIX. If the operator is requesting a renewal to continue up to 5 additional years, evidence that the LMO will continue beyond that 5 years is required. I don't understand the necessity of this entire subsection, why this evidence is needed.
The question, you want it tightened up more? Or you just want it?
Mr. Chairman, in the 2017-18 session, we passed a 5-year term renewal requirement on limited mine operations. We set in rule and guidance both some reasons why you would just pretty much automatically be renewed. What's in the bill codifies those actions.
Understood.
So, for example, if generally on a YDOT project, they're bidding 3 years ahead of time. if you come up on your 5th year in your LMO and you know that you've got a YDOT project coming up, you tell us that, you know that you have that happening. That's just pretty much an automatic renewal then of the LMO for the next 5-year term.
Good. How many more questions do you have, ma'am? How
Just
many more?
just one.
Okay, all yours. Go ahead.
Thank you, Chairman, and thank you for that answer. I appreciate that very much. Under pages 3 and 4, how do these bonding, I might not have worded this very well. How do these bonding increases fall in line with actual costs, especially for such innocuous materials like sand and gravel, scoria, dolomite, ballast, and feldspar?
Okay, you want
Mr. Chairman, as I testified back in February, we had recently just bid and contracted out 2 new sites. We're actually a 3rd one now. We were roughly 19 on, and without those were under the old $2,000 and $3,000 per acre rate. We came up short about 19,000 on one and 5,000. We were about $5 long on the other. If you would have applied the new rates, we would have been dead on. So the new rates are based around, none of the bonding rates had been changed since 2014. We've had 10 years of inflation. The bonding rates of the 5,000 and 7,000 per acre on those rates were set to adjust for those inflation over that period of time. And then also we added, which has never been an option for operators in the past, to do a full cost bond. So you could do the per acre rate, or you could come in with a full cost engineered bond, whatever was best for the operator.
Understood. Okay, thank you. Thank you for joining us from Buffalo, correct?
Thank you
What
very
did
much.
you do
Yes,
with
Buffalo.
what was your title with, what was your title with the BLM?
Geologist.
What was your title with? Okay, thank you. Appreciate you joining us today.
Thank you so much, Chairman.
Okay. Okay, very good. Oh, go ahead, sir.
Mr. Chairman, if I may, I'm going to make a personal observation because one of the questions that was posed and not directly answered by the last speaker was, it's going to raise the costs on a few things. I would just opine that both the Wyoming Mining Association and the Association of General Contractors spoke on support of the bill. It would be my assumption that they have taken a hard look at it, figured out what additional costs would be. And in light of their support, I think it could be opined that they're okay with any costs that might be associated with the changes.
Okay, fair enough. Did we have anybody else on? That's it. Committee, what's your pleasure with this bill?
Move the draft.
Have a second? Move to
And-
second.
Mr. Chairman, that movement of the draft would be, and I don't think we need to vote on it because it was an alternative in here. My alternative on that is the alternative recommended in the staff comment on page 4. Alternative to paragraph B.
Staff, do you want to follow up on that at all?
Yep. Mr. Chairman, Chairman Burkhart, you can just treat that as like you would an amendment, just move the staff comment
Okay.
if that's your desire.
Do you want to take care of all the amendments at one time, Mr. Co-Chair?
I think Mr. Chairman, I think we need to take care of the bill and then, I'll make that amendment that we incorporate the staff comment.
Okay,
Well,
further discussion and then we'll.
Mr. Chairman, I think it's in order
Okay.
right now, Mr. Chairman.
Oh,
for
it
you to
is,
make a-
okay.
yeah.
Okay.
Please
All right.
proceed then.
So, Mr. Chairman, my motion would be to draft the bill using the staff comment that starts on page 4 and to also incorporate the amendments so recommended or suggested by the department.
It's a motion to do that. Is there a second? There is a second. Is everybody clear on what we're doing? Okay, we're good. Any further discussion? Go ahead.
Thanks, Mr. Chairman. So the one concern, and it's my understanding that we're just moving to draft, well, I'll start with that. It's my understanding we're just moving to create a draft for us to consider at the next meeting.
Correct.
That's what I'm understanding the motion was from co-chairman. Is that accurate? Okay, good.
Correct.
So the one point of consideration is, and again, this is very similar to what we did in the last legislative session, but the remaining consternation comes down to the idea that we're changing what is qualified under this from sand, gravel, et cetera, to any non-coal minerals where the non-coal minerals may effectively be mining operations instead of an exemption from a mining operation permit. And I guess that's something for us to consider and maybe get more feedback on. We anticipate lithium and rare earths. There's probably gold and other
Right.
precious metals.
More to come.
More to come there. I guess the question that I would ask as we consider this is, are we creating a mini mining permit where you're actually going to have mining operations taking place when the original limited mining operation was just for inert, innocuous materials that you basically scrape and then haul off in a vehicle?
I see your concerns. I don't sense that's the case. I'm gonna allow the department to step back in and comment on that.
Mr. Chairman, I don't see it that way. I see it that you have a limited size of a small development. We're talking about 15 acres, 3 house foundations. It is an exemption in the notification, but it's limited to its size and scale.
Right. So I'm seeing it. Mr. Co-Chair, do you want to offer? Okay.
I would, Mr. Chairman, I would agree with the agency on this. I don't see it. The only thing you could do on call it a mineral mine would be to pull some samples. I mean, most of these mines are going to have to get a full mining permit for, call it, large mines very quickly. About the only thing I think you could do with say we found lithium and the lithium mine is to pull samples, you'll disturb 15 acres, if not more, doing that. And it includes the roads. And some of these are going to take roads that are quite long. So I don't think we have that big of a problem.
A lot of concern, Senator Rothfuss.
Yeah, Mr. Chairman, I think the key is what methodology they'll use. Right now, the materials that you would be collecting are just that. You might blast a little bit, but you're going to drag off rock. You wouldn't be doing any acid mining. You wouldn't be doing any techniques that would potentially cause concern that are the types of things that would be considered during a mining permit, where you would actually be looking at a more comprehensive picture than just what is your surface disturbance. So I guess that's the concern that we're hearing, is that you might have considerations that are not going to public concern that might affect land quality, water quality, and air quality. I realize that, and maybe the answer is just that permits would be required for any of those things, but this seems very different, right? The limited mining operation was to get gravel from a small area once in a while off of your own property. This seems like it's a significant potential departure of use cases. And to the extent that we already see some businesses around the state trying to use the LMO as a loophole to avoid mining permits, I guess I'm just wary to create more room for that exploitation.
Appreciate your concern. I don't know that we are there yet, but let's have Alan comment. And then we're going to bring it back and take care of the vote on the staff comments and the amendments. Sir?
Yeah, thank you, Mr. Chairman. Again, Alan Edwards. I would like to state officially that I think Kyle adequately responded to that question, but I'd like to follow up on the last comment that Co-Chair Burkhart raised, because some of those LMOs will have long roads. I'd like to reiterate the discussion that came in earlier that even though the roads aren't included in the 15 acres, they are required to be fully reclaimed as part of the LMO. So there is a total reclamation responsibility, and I just wanted to make sure that was clear.
Appreciate you clarifying that. Thank you.
Mr. Chairman, if I might, I think we attempted to address some of the concerns of Senator Rothfuss in the fact that when you look at the bonding structure, we said if it's not one of the aggregate categories, you have to full cost bond, assuming that if you did wind up with an acid generating rock issue, you would have adequate resources to cap that and deal with that. And then also, the statement is correct that you still have to go get a water permit and you still have to go get an air permit beyond the LMO notification. And then the last thing I would just add, just for the committee as a whole, I've researched out the LMO history pretty extensively. And there is nothing in the statement of reason or factual record that these were ever designed for exclusively private landowners. Actually, to the contrary, there's recognition back in the act in 1973 where that kind of started, and then in the middle 90s, around 96, 97, when LMOs took off, that there's 51% of the state is federal surface, 62% approximately federal mineral. I have as many LMOs on public lands, public federal lands, as I do on non-federal lands across the state. So I think there was recognition even then that these operations would be on multiple land surfaces across the state. They were never just for private landowners.
Okay, thank you. All right, with that, we do have a motion on the floor for the staff comment and the amendments. With that, all those in favor, say aye.
Aye.
Those opposed, nay. Add those, Brian, we're good? Okay, we're back on.
Mr. Chairman, just so clarify for staff, that is to prepare a draft for final review next committee meeting.
I think they understood that, but we're good?
Yep. Yeah, Mr. Chairman, it'll just be a new version of this draft.
Yeah, with these additions.
And Mr. Chairman, if I might, if everyone notices, this is the first bill to be drafted for the 2025 session.
It is. And with that, we still have to actually vote on the bill, as I understand it. So all those, any further discussion? Yeah, that's what we just did just now. We included. Yeah. Amendments and staff comments. So we're back on the bill. Any further discussion? All those in favor say aye. Those opposed, nay. Draft bill ready for next session. Next time we meet. With that, we have a couple of informational pieces. Looks like you gentlemen, do you need to stay with that? Because it's industrial siting rules, abandoned mine land. It's all yours? Oh, you got some more help? Okay.
Yes, Mr. Chairman. Again, Alan Edwards, the Deputy Director. And I do want to introduce the new administrator, the Industrial Siting Division, Jenny Staben. She has the presentation, but before she starts, I have just a little bit of background to provide. Jenny came to us out of the Attorney General's office, and she in fact was the industrial siting attorney for a period of time. So she came to the Industrial Siting Division with already a good experience base for the project.
You come well experienced. Go ahead. Just state your name for the record too.
Thank you, Chairman. Thank you, committee members. My name is Jenny Staben. I'm the Administrator of Industrial Siting at DEQ. And I'm looking forward today to just going through an overview of the industrial siting program for you. However, if any of you have any questions, please feel free to interrupt me at any point in time.
Okay, go ahead.
The industrial siting, industrial siting was established by the Industrial Siting Development and Informational Act in 1975. In 1992, it became a division within DEQ. Today in 2024, the division is made up of 3 full-time employees, myself, and 2 employees. I think the main takeaway from this slide is that I have a very small division, but we are very mighty. We are at this point in time monitoring 20 industrial facilities, and we expect to have 5 new industrial facility projects permitted by the end of the year. An industrial siting permit is actually a permit that is determined by the Industrial Siting Council, the Industrial Siting Division. At DEQ, we are considered the administrative arm of the council. It is the council that decides whether a permit is granted, what the conditions are on a permit, and the amount or dollar amount, I should say, of impact assistance payments that would be provided to local governments that are impacted by the project. The council itself is made up of 7 citizens here in Wyoming. They are all well educated and spend a significant amount of time in their determinations. The council is charged with assessing and controlling environmental, social, and economic impacts that may be caused by the facility. They do this by taking in comment from 19 different state agencies, comments from local governments and their concerns, mineral right owners, local residents, and other parties. The council is also charged in evaluating and determining the amount of impact assistance to be dispersed to local governments now that are impacted by the project. Now, it is up to the local governments to determine what those impacts may be and what dollar amount may be attached to those impacts. The Industrial Siting Council, in making their determination, that determination is made during a contested case hearing. At the hearing, parties include my division, who makes a recommendation on the completeness of the application, the permit applicant, as well as the different local governments who are requesting impact assistance payments, and any other parties, including neighbors, local landowners, mineral right owners, are also parties to that contested case hearing and heard by the council. The jurisdiction of the industrial siting, our jurisdictional threshold is a construction cost of about 283 million or more, or if it is a wind project, it is 20 turbines or more. Or if a current wind facility is expanded to more than 20 turbines. For solar projects, it is 30 megawatts, or if at least 100 acres of surface will be disturbed. Or if you have a current solar facility, if you will increase your number of panels to the megawattage to 30 megawatts or more, or disturb at least 100 acres. The Industrial Siting Division does not have jurisdiction if it's construction of a non-mineral processing facility in an industrial park. An example of this could be a data center. We do not have jurisdiction over state and local government construction, election transmission lines of less than 160,000 volts, or oil, gas drilling, extraction, or well field activities. Now, local governments who are impacted by the industrial facility, the construction thereof or operation. The clearest way that I explain this when I'm speaking with local governments is for local governments to envision when this workforce comes into your county, or when this project, as it's being built in your county, how does that impact your local governments, including organizations organized under the Joint Powers Act? So, and those are the impacts that you may receive impact assistance payments for. We call those unmitigated impacts. So you're really looking at a new issue that this workforce may cause, or how it may exacerbate a concern within your community. Typically, these are concerns. The workforce typically impacts medical, fire, and law enforcement services, they may also request impact assistance for road and utility issues. The only unique issue with that is that the local governments would have to show that they can't address this workforce coming into their county without additional employee overtime or without making additional contracting labor. Now, how impact assistance is calculated. Initially, in the early years, it was what I call a baseline calculation method, which essentially, when a construction project came in, there was a calculation done to figure out how much impact assistance the local governments may receive. And that amount was basically layered on top of the sales and use tax that the local government received the year before. So it was a combined number between the dollar amount of the impact assistance available plus the sales and use tax that the county or community received prior. The problem with that was it was all based on the year before. So if the local government or the county, I should say, let's say through their sales and use tax, gained the same amount of money they would have if they were given impact assistance in the previous year, then in the current year, they wouldn't receive impact assistance. Same thing if in the previous year, they did not receive through their sales and use tax the amount of money that they would have received if they got the impact assistance, then they would receive that assistance in the current year. The problem is inherently it left communities unable to plan forward or really be guaranteed a certain amount of money annually for the projects and issues they wanted to address. Also, at that time, the local governments did not have to provide a clear justification for the impact assistance and as to why they would require it. So a solution came, which I call the flat percentage method, and this was in the early 2000s. And in that, the impact assistance, which I should clarify, is based on a percentage of the materials and construction costs within the county of the project where the project is located. The flat percentage was basically, it was a 2.76% estimated construction cost that was available for impact assistance. And then it was up to the local governments to decide what percentage of that they would be entitled to, again, without clear justification for the request. Today, impact assistance is determined using what I would call a fixed tiered method. You take the estimated construction costs and that determines the dollar amount for impact assistance. On my next slide, I'll show you how that breaks out percentage and dollar wise. The other difference is that today local governments have to appear in front of the Industrial Siting Council and they have to make a legitimate and clear justification for their request. They need to explain how because of this workforce and because of this construction in their community, how that is specifically impacting their community and what the cost is of that impact. Here, I've just decided to do a clear table of what those percentages for the maximum percentage that can be awarded for impact assistance based on the estimated construction cost. And as you can see, if it's about 350 million or less, it's 2.25%. Then again, 2% if it's between 350 million to 850 million, and 1.5% if it's 850 million or more. I do want to point out that when the construction cost is 350 million or less, the council may award a higher percentage of up to 2.76%. However, if the council does choose to award that to the local governments requesting impact assistance, within 10 days, the council would have to provide to you a report that clearly explains and justifies why they have increased that percentage. Here, I'm sure is a slide that is much easier for you to read on laptops or even in a handout. I just thought I would list the projects that are currently under construction. As you can see, the first two are the impact assistance was based on that baseline calculation that was determined by the sales and use tax the county received in the previous year. And then the percentages were split up by county. Further down, you can see that the 2.76%, that was that flat percentage, which was the standard for a number of years. And at the very bottom, you will see the beginnings of the tiered approach that is used today to determine the percentage of impact assistance payments that can be awarded. So today, just in summary, we have under construction, as you can see, 5 wind facility projects, 1 solar transmission line, a carbon capture project, and 1 Trona mine. In this slide, what I do want to point out is that of the maximum amount of impact assistance that could be awarded for these projects that are under construction, the previous council basically awarded an average of 60.25% of the amount, the full amount that could have been awarded at that time. They awarded about 60%. This is just a chart that includes all of the pending construction. These are projects that do have a permit from the Industrial Siting Council, but they have not started construction yet. And you can see here, a bit of a difference is that under the current council, of the total amount of impact assistance that can be awarded to local governments, the current council, using the system of where they have to be specific in the request and justify a linkage between the workforce and the cost of the communities, of the total amount that is available, they typically on average award about 41%. Here, my statement regarding 41% is made a bit more clear in my summary slide. But at this time, we have pending construction 4 wind facilities, a soda ash refinery expansion, and then, of course, CK Gold right outside of Cheyenne. I do want to add the 3 solar that are listed there. Cowboy Solar, which is a project just south of Cheyenne, just received their order and permit from Industrial Siting. Over the past 10 years, Industrial Siting, this is just a summary of the projects that have been approved and received a permit from the Industrial Siting Council. So in the past 10 years, about 25 projects have been approved. And this, using our current statutory tier estimate of impact assistance, is what we have scheduled for 2024. So we are looking at having 6 new industrial facilities permitted before the end of the year. We have 2 solar, a wind, 2 Trona mines, and also potentially another wind project. Within the construction over the next 2 years, we do have a number of solar projects that we are expecting to come in. Of course, and the nuclear demonstration project. Because my office has received so many inquiries regarding wind projects as well as solar projects, and they seem to be of significant interest at this time, are renewables. I just thought I would provide to you this map of the wind projects here in Wyoming that have already received a permit from the Industrial Siting Council.
These are permitted but not built yet.
These are, it's a mixture of permitted
Okay,
and also built.
thank you.
And this is just also showing where the solar projects that have been permitted are.
Okay.
And that is all I have for my overview today.
Inquiries on wind, they're just, I don't know how you make the call. They're serious, they're ready to fill out the forms, are ready to get involved. What, you say there's a lot of interest in wind.
Yes, it's essentially it ranges from companies that already have wind facilities permitted and they're looking for expansion, or they're looking to have
So these
other facilities in the area.
There's a serious interest and they're ready to
There's a
go.
serious interest.
They're ready to move.
They are ready to move, but not quite yet ready to bring an application into the division.
Okay, this is what I was trying to distinguish. Thank you. Committee?
If I may, Chairman, Wyoming provides some of the most fantastic wind in the United States for a significant number of days compared to any other
I was
state.
just hearing my colleagues confirm that quietly.
Mhm.
Okay, thank you. Go ahead.
And Mr. Chairman, in response to your question, as Jenny was coming up here, I'm going to sit in on this one. I am sitting in on this one and the next one to offer just a couple of agency comments relative to the update that was requested. First, with Jenny's presentation, you can tell that between being in the AG's office and being the administrator since December, she's got a very good handle on the program, so that's working out very well for us. One item of clarification, she mentioned she had 2 staff. Technically, that's not correct yet, but it gives us an opportunity as an agency to once again thank the governor, the Joint Appropriations Committee, and the legislature for the positive attention to the staffing challenges that DEQ had.
It'll just get bigger.
So through the budget process, there was a position added to industrial siting because all the workload coming down, that though will not technically be effective until July 1. So just a point of clarification. And then relative, as many of you know, I was the industrial siting administrator for a while. But based upon my personal experience with the council and the follow-on exposure I've had with how they're working, I think the state is very well served by the 7 volunteer members who serve on the council. I have been impressed with all their other work that they do because they all have real lives somewhere else. They review the applications. They ask all the right questions. The hearings are bifurcated. They deal with the permit up front and they ask hard questions. When it comes to the impact assistance, they're very focused. They've done their homework and they have been consistent in not awarding impact assistance unless they feel there's a direct link and they're directly impacted by the project as proposed. And so I think as an agency, we'd like to give a shout out, a thank you for them taking their time, but also for the good work they're doing.
Sounds like they are. Good, thank you. Committee, go ahead.
Thank you, Mr. Chairman. Dr. Staven, question about the reporting or transparency for the awards that are giving out. You've had over a year now that these new regulations have been imposed where they have to report. How is that working? Are the reports being filled out properly? Or are you getting the information you need to ascertain whether these funds are being utilized as awarded? Any gaps there that you can see at this point?
Go ahead.
Chairman, committee members, sir, frankly, from the point in time when that became a requirement, the reporting, we are just now to receive our reports. So quite frankly, that would apply to one solar project at this time and everyone else going forward. What the division did do was provide a template to the local governments of what information would be required for that reporting. So in simply just filling out the template, they will be providing information that will enable the division to cohesively understand what they're spending the money on and to see if it aligns with the award provided by the council.
Okay, Alan, let's follow
Yeah,
up.
and
Good.
just as a follow-up to that and to embellish what Jenny mentioned, not only is there a template, but kudos to the division because they created it as a fillable PDF so that it will reduce the reporting burden on the local jurisdictions who are receiving that. Because by being a fillable PDF, as they incur a cost directly related to the project, it gives them the opportunity to simply add that to the list. So they just build the list as they go, and then they turn that in at the end of the year and then start the next list. So the division took extra pains to try to make it as easy as possible because we have a lot of very small local jurisdictions with a very small staff. The intent was to make it as simple as possible.
Good.
Yes.
All right, good.
Follow up.
So go ahead.
Thank you, Mr. Chairman. It's actually not a follow-up, though. It's another question.
Okay.
Part of the unmitigated impacts are road use, repairing and maintenance on roads that are impacted by a construction project. But if a county identifies a road that is going to be impacted that was not identified in the construction use plan of the company that is doing the construction, how is it possible to get mitigation funds for that road that was not identified by the company, but that the county feels will be impacted?
Oh, good road question. Go ahead.
Chairman, committee members, the identification of the road can be handled in a couple of ways. The applicant for the permit could approach the county. The county can approach the applicant for the permit and request that they make an agreement amongst themselves for that type of maintenance to occur. Or the county may come and appear in front of the council and explain to the council and basically put on their case through their legal representation of why they believe that road is being impacted.
Okay.
A second level to put on that is if a county does believe that they are being impacted, if the county believes it's being impacted and is concerned an applicant will not assist them or come to an agreement, on that county usage, the county can also ask for that to become a condition on the permit for the applicant to work with the county on a road use agreement. So there's a couple of ways to approach it.
Good.
Okay.
Okay. All right. For the question, go ahead, Al.
And Mr. Chairman, since Jeremiah is still here, I want to give also a thank you to the County Commissioners Association regarding the fillable PDF. The county commissioners took the lead on getting that circulated out to some of the commissioners. It went through like 3 different iterations, and then it finally went through the County Clerks Association, who, when the agency thought we had a beautiful form, they came back and said there was a certain amount of confusion. So due to the work through the County Commissioners Association to get that, we were able to incorporate the feedback even from the county clerks. So we're very grateful for that assistance.
Very good. Appreciate it. To the
Mr. Chairman?
Commissioners Association. Go ahead.
Thank you, Mr. Chairman. I want to thank you for your presentation. I thought it was really well done. But as I'm sitting here and a light bulb literally went off. And so I haven't talked to anyone about this, but the purpose of industrial siting is to recognize impacts on neighboring local governments. And so I'm reading the statute right now, and you talked about, if local, state, federal financial resources aren't available, then they come to you. And then reading the statute in its entirety, it talks about notification requirements for local governments. I chair the Select Committee on Tribal Relations, and it dawned on me that I don't think that those same requirements apply if they affect a tribal community on the reservation. So that's my first question. But looking at the map, and I know this is a bit of an academic question, looking at the map you provided in your handout, maybe there haven't been, projects located near a reservation or nearby reservation community. But I'm just wondering if that's something your agency's considered, and maybe something we need to kind of explore a little bit more is what kind of relationship should we be having with our tribal partners if there were to be a solar or wind project developed outside the reservation, but it would clearly impact their community. So I'm just kind of curious if that's been something you've thought about.
Which one of you would like to take then?
I would like to, Chairman, committee members, I would like to take the first stab at that. At this point in time, the tribal communities are notified of the projects, and they can then comment on it. And if they want to be involved in the process, they can become involved in the process at that time. To my knowledge, I don't believe a tribal community has become involved in the industrial siting process, but I would have to defer to Deputy Edwards.
Mr. Chairman, to my knowledge as well, they have not approached and asked to be a party. Jenny left the implication that she'd take the first shot at, as in though I would have more to offer, and it might surprise you that this time I do not.
Mr. Chairman, a follow-up?
All right, go ahead.
Just a follow-up. I know that's the practice, but I'm reading the statute and, we're trying to develop positive relationships with our tribes. And so if it's already the practice, I'm just wondering if there would be any harm in codifying that. And I don't think it's a simple insertion that we can cover today of adding the words "and tribal" in certain parts of the statute, but
Senator, do you want to
would
take a
you-
look at it and get
but
it ready
what
for
I'm-
next meeting?
what I'm trying to ask is, would you, if we worked on it to bring a bill for the next meeting, to really just codify what your practice is so that they know that we're serious about that notification requirement. And then down the road, if you're not the administrator and the practice falls apart, then at least that requirement's still there. I think my concern is just the longevity of it. So would you be willing to work with me on bringing a bill to this committee for its review? And I want it to be consistent with what you do already.
That's a yes.
Chairman and committee members, absolutely, ma'am.
It's not on our list, but it obviously needs to be clarified. So, okay. All right.
Mr. Chairman.
Oh, go ahead.
Mr. Chairman, I was wondering, the wind projects map that you provided, is there any way to get them by county so that we can all look and see exactly where they're proposed to be located in our specific counties?
Mr. Chairman, committee members, I am very pleased you've asked that question. The Industrial Siting Division, we are actually moving into an online software program. Currently the permitting process comes in, through mail and emails and that sort of thing. And we are actually joining the WIM Solutions program. It will be where applicants will bring their information to us in electronically. And basically we'll be moving into the technology of 2024 and very excited about it because this program will allow any citizen to be able to go online and there'll be a map of Wyoming and they will be able to click on the county, the project, and it will offer, I would say like a logistic transparency to the projects, where their boundaries are, what counties they're in, and it will give a brief description. But I'd be more than happy to provide the committee with a full map of the projects by county. Absolutely.
Senator Jones?
Thank you very much. I would appreciate that.
Okay, got a lot on coming up. But that new change that will show us, because the first map you showed us, it was like everything that was underway and already built was one and the same. This would separate what's proposed and what is already built, right?
Chairman, committee members, absolutely, I can make that available to you. We can add topography, whatever you all require.
Very good. All right. Representative Heiner,
Thank you, Mr. Chairman.
you're getting a lot of questions here.
And my apologies for being part of that, but I do have some questions that I'd like to be addressed here. Dr. Staben, with the nuclear demonstration facility going to be built in southwest Wyoming, the NRC will have jurisdiction over a portion of that, which I believe will be outside the purview of in the Industrial Siting Act. Is that correct?
Go ahead.
Chairman, committee members, yes, that is correct, sir.
So with follow-up, Mr. Chairman, so with that being said, the expenditures and monies being spent on that NRC portion will not be able to be utilized for unmitigated costs, right? Is that correct?
Chairman, committee members, essentially, sir, what the NRC will cover, is more focused on what the NRC licensing will cover. So the NRC will have to do an environmental assessment, and what the federal environmental assessments require as far as analysis for environmental impacts and impacts within the area are more in depth than what's typically required for your usual industrial siting permit. And so by statute, we have figured out that a number of the studies that will be cited in that environmental assessment can then just be incorporated into the industrial siting state permit. But as far as the impact assistant payments, those will still be calculated as per usual, as they usually are. And the difference is for the industrial siting permit for the nuclear demonstration project, what the company will have to do is they will have to make more of a customized analysis on the socioeconomic impact. So the impact is on the actual community. So the impact assistant payments can be calculated from that.
Follow up, Mr. Chairman. Thank you. So just to be clear, if the whole demonstration plant, nuclear demonstration plant costs, let's say $4 billion, will the impact assistance fees be based on the 4 billion or just the 1 billion of ancillary outside of the NRC nuclear island?
Go ahead.
Chairman, committee members, it's my understanding that the first step will be the test and fill facility with the Natrium demonstration project. The division previously determined that that was non-jurisdictional, so it will not include the test and fill. As far as what I would call the actual nuclear, yes, exactly, island, that the impact assistance payments may be calculated off of that.
Good. Okay. Further questions?
Mr. Chairman?
Oh, go ahead, Alan.
I would just note that the division worked really closely with both NRC, but primarily TerraPower to identify that clear division that is articulated under 3511-2101. So there's in essence, and correct me if I misstate this, Jenny, but there's essentially only the two issues that are left that NRC doesn't cover. One is the water. They do indirectly touch on the water, but not necessarily the water quantity. So we've identified that as one, but that's very simple because they need to get a state engineer's permit or transfer or whatever to use the water. So all they need to do is to submit that agreement with the application. And then the other is, as Administrator Stevens said, is to get enough information to address the socioeconomic unmitigated impacts. So those are the two primary elements.
Okay, good. Further, Mr. Co-Chair?
So thank you, Mr. Chairman. So while I have both of you here, and I'll start with you, Ms. Staven, something I've always looked at in the industrial siting requirements that I think is a disconnect. When you look at the history, they were designed to take care of communities for large construction projects where thousands, hundreds, thousands of people were brought in for a major construction project, but it was based on the cost. How do you address the issue of large cost, low employment impacts versus low cost, large employment? And for example, a power line could cost $1 billion and only take a few hundred people to put in, and those people are never in one place very long. They move right through the community with the power line versus a $200 million project that might employ 1,500 people coming into a community.
Go ahead.
No, we're not trying to put you on the spot, but we are. Yeah.
There were several questions in there.
Chairman and committee members. I would have to say, it's my understanding, based on the projects that I see before the division at this point in time, and the few and my knowledge as the attorney for the last year before this, it appears that a number of these projects, first, they do have to make effort to employ folks within Wyoming for these projects, and that the workforces coming in are really pretty high in numbers. As far as how then these funds need to be made available to the local communities, a lot of these projects that are coming in are just such a significant benefit to the communities, and also bringing in a significant tax flow with their workforce. And honestly, sir, in this moment, I'm not sure I'm answering your question.
Let's finish up the question here and hang on just a second, please. Minimal questioning. Go ahead.
So, yeah, Ms. Stabner, the issue being, for example, a power line, and that's a good example where it's going to be $1 billion project, and they might only have 200 people who start at one end and move to the other. That comes in under industrial siting under our $283 million cutoff point. Versus, and I'll just use TerraPower, you mentioned it, TerraPower's test and fill facility, this comes in under that number that may employ 1,000 people to build that, a very highly technical facility. How do you address those issues, or should we, as the legislature, start looking at those issues?
Go ahead.
And I think Mr. Edwards would like to just jump in and give you a break.
That seems appropriate, sir.
No, I'll approach it from a different direction, because as Jenny pointed out in her presentation, there's a sliding scale for impact assistance that's based upon cost. So let's say you have a large project with a small number of people. The community still have to come in and demonstrate what the impact of that influx of people would be. And then that's what the impact assistance would actually be based on. It would be the local impact. If there's a project that is sort of small, but is jurisdictional, but has a very large population base. If you noticed in the smallest cost category, the council has the ability to increase the impact assistance from the maximum from 2.25 to 2.76. So the way the statute is worded, it does give some flexibility. Now that is, if that is perfect and a catch-all for everything, I think the formula, to the credit of the folks who had looked at all that, tries to bake that in. They only get impact assistance if there's truly unmitigated impact. And if there's more impact than folks might imagine, there's an option for the council, which I will note, if the council exceeds the 2.25, they're required to submit within X number of days a report as to why they went over the baseline number. So
That's true.
my thought is they're baked in there.
Okay, you good? I'm good. Go ahead.
Thank you, Mr. Chairman. Could you walk me through the timetable on the payments? Like what I'm focused on is, do these communities that pass the testing that you do, the reporting, the going through the council and getting approved, how does it walk me through a timeline? Because I'm focused on, are they getting the money in a timely way that can make a difference to mitigate the impact that this facility would provide? So
Okay.
can you walk me through that?
I'll let you both answer that. I got to consult with my colleague for just a moment, but please continue to answer and go directly to the representative on that.
Representative Lawley, the impact assistant payments begin once construction starts. So as the statute's currently written, because those impact assistant payments are based on the sales and use costs associated with the construction or the purchase of the materials, and those actual payments do not begin until construction begins. So, and based on the tables I provided, you can see how a number of those projects, they get their industrial siting permit, but they have up to 3 years to start construction. So for a number of communities, those payments, they won't start, and it doesn't start until construction begins.
Okay, Alan, do you want to follow up?
She I think identified that very clear, because the division notifies the Department of Revenue. My apologies, Mr. Chairman. The division notifies the Department of Revenue when construction starts, so there's monthly payments that go to the community. Now and that's typically an even amount over the months for the period of the construction.
Mm-hmm.
So there is a relatively timely flow of funding. And then, Mr. Chairman, could I add one point of clarification? I just want to make sure it's clear for the record.
Please.
In response to the question by Representative Heiner, Jenny accurately addressed the test and fill facility, and that is a non-jurisdictional facility. But I think for the record, I want to make sure that it is clear that the test and fill is not directly associated with the reactor facility. It's a totally separate test facility that not only would serve to test equipment for TerraPower, but also for any other facility that is going to be going into the nuclear arena. So it's important to note they're two separate projects for a variety of reasons. So they are two separate.
Yes, they are. Okay. All right. Any further questions? Go ahead. You are very popular today.
Thank you, Mr. Chairman. I just had one clarifying question. So once the permit has been issued, that's when our communities can actually apply for the impact assistance, and then it won't be issued until after construction begins?
Senator Jones, the same hearing in which a permit is granted or the conditions on it, the second half of that hearing is when the communities come forward and request their impact assistance payments. And on that same day is when the council determines what that dollar amount would be for the impact assistance payments. So the request is made the same day that a permit is asked to be granted. As far as when those payments began, because the payments are based on the sales and use taxes associated with the construction project actually happening, it's not until construction begins that triggers the Department of Revenue to release impact assistance funds to the counties.
Okay. Okay, I hear on this side, our Representative Larson, I called you by your initials.
Thank you, Mr. Chairman. So what is the average timeline between the time you issue the permit and construction? What's your average time frame for, or does it vary on every project or?
Go ahead.
I believe it varies on every project, but I'd have to defer to Deputy Edwards.
Mr. Edwards.
There have been some projects that have been permitted in the past, let's say up to 3 years ago, that are still sort of languishing. Other projects, for an example, the Project West, the new Trona and processing facility, they're up for their council hearing next week. So the council will make a decision on their permit. It's my understanding that they might start early in 2025. So it is variable. But the larger projects tend to want to move quickly because they've invested the finances to get to that point.
Okay. Is that covered for you? Further comments? All right. This has been informative. Thank you. Understand that these legislators have to go back and answer to their communities, and so they wanted to be informed when they go back home. Okay, thank you. This does it. Yeah, I'm getting there. I'm finally learning after a full day.
Yeah, but Mr. Chairman, we do it.
Well, let me just insert this. Mr. Edwards, I would say the DEQ has gained, the Attorney General has lost. So good move. Whatever you did, good move.
I would second that motion. And as a matter of fact, we did sort of hear from a couple of the AGs about.
I sense you'll be crossways with the AG's office for a while. Okay, public comment. Oh, GT.
Thank you, Mr. Chairman. So just one more clarifying question, I think it's pretty obvious, but you say you have jurisdiction if the construction is 283 million or more. So the numbers we've been referencing of $200 million projects would not even fall under your jurisdiction for an industrial siding project, correct?
That is correct, Representative Larson.
Okay. All right, thank you. Okay, appreciate you too. Public comment, county commissioners, I saw you making a move.
Good afternoon, Mr. Chairman, members of the committee. I'm Jeremiah Reaman here on behalf of the Wyoming County Commissioners Association. I just wanted to expand on one portion of the testimony in response to Representative Heiner's question about reporting. And really appreciate the collaboration and the recognition of the work that we did to put that reporting form together. The department reached out to us. We had many iterations of work through that process. And as Ms. Staben referenced, local governments are not required to begin reporting until this new process starts, which really is only one project at this point in time. But I want to make it very clear that as part of that process for us to develop this reporting, my members, the counties, actually submitted 3 years of past data. So if you're interested in any of that reporting for those projects, we'll happily turn it over. We were very happy. I was very adamant during this conversation a couple of years ago that we would comply with reporting, that we wanted to see that reporting. And so we stepped up and put that forward. I can't speak for the municipalities about whether they did that, but my members did. Mr. Chairman, the last thing I'll say, and I don't know if this is public yet or official, but we have at least one county that's going to be returning funds because they had requested them for a particular project. That project did not come to fruition for a variety of reasons. And so they will be sending a rather large check back to the state of Wyoming here shortly. And again, that's a testament that we're not just going out and buying popcorn machines with this money. We're putting it on the ground where we said we were going to put it on the ground. when we made the request to the agency for those funds. With that, Mr. Chairman, I'd be happy to answer any questions.
Tell the county, thank you. All right, go ahead.
Thank you, Mr. Chairman. Mr. Ryman, I applaud that. I think that's wonderful, but a little clarification for me. The payments begin when construction begins. So are you saying that this project began construction and then stopped for one reason or other? And, how, the question is, how did these payments get to the municipalities and the counties that they had to return them or chose to return them?
Yeah, Mr. Chairman and Mr. Edwards may be able to come in on the backside of this, but it's a completed project. But those payments, of course, start when construction starts, and the funds accumulate to the local government to then act on the project that ultimately they were going to undertake. Because of some wranglings with various parties, they weren't able to actually undertake that project. So they've accumulated those funds. They now need to return them, and that's what they intend to do.
The follow-up and then to Representative Larson.
Yes, thank you, Mr. Chairman. So this probably was before the transparency and reporting requirements were instigated. So they're doing this out of their own goodness of their heart rather than being required to do this. Is that correct, Mr. Ryman?
Go ahead.
Mr. Chairman, that's absolutely correct.
That is very, very commendable. Yes.
Chris, Representative Larson.
Thank you, Mr. Chairman. So, Mr. Ryman, does the current tiered system of the industrial siding that was implemented a few years back, is that serving adequately your members, or do your members feel that it needs to be expanded?
Go ahead.
Mr. Chairman, Representative Larson, it's a great question. I'm very proud to have worked with Representative Heiner and Representative Lloyd Larson on that particular legislation. And just as a little bit of background, the reason, in fact, we're the ones that brought forward that tier system, understanding the issues that were at play at that particular time. The system as it exists was set up such that typically for those smaller projects, you need more of this impact assistance because you don't get the same volume of tax revenue. And the reason that this program exists is because typically for local governments, your tax revenue is delayed some period of time. So you need to have a source of revenue in order to act on that. And so we felt you needed to have that higher percentage for those lower dollar projects. We did think that you needed to have the ability to go above that 2.25%. But my members also felt that for those much larger projects, you could have a lower percentage associated with that. That's why we conceded to the tiers that exist there. A couple of things that I'll just say quickly to that, and I don't think I'm going to be saying anything out of turn that I haven't said to Representative Heiner in those conversations as we negotiated this, is that I still think that there is the need for certain projects potentially. We don't know what's on the horizon. Things are always changing. Maybe a new community that's going to get something that's never had an impact assistance, that you should have, or the council should have, the ability to go above those tiers that are set there. Now, I'm not opposed to the notion that those, if they did go to that they might have to come back to, say, the legislature, similar to the Wildlife and Natural Resource Trust when you go over the thresholds that exist there. So that's one thing that perhaps we can visit in the future. There may be some other things that we need to take a look at as we go forward. In particular, that $350 million, we're getting a lot closer with the size of projects that are on that lower end. And at some point, I don't know if it's 10 years in the horizon, but at some point that lower tier is not even going to exist anymore because the minimum threshold is going to be over it. So we might need to to have a consideration of whether we should move that tier. I'm not saying that's today or if it's in the future, but those are just a couple of things that might be responsive to that.
Good, good. Oh, go ahead, Alan.
Since Jeremiah raised the issue, I'll jump into that on the project, just to make sure the definition is clear. The industrial siting project was permitted and built. During the permitting process, as I understand it, the local county identified an unmitigated need that they felt needed to be put in place. As I understand it, due to a variety of factors, the improvement project that they had identified was not built. So it was an element of cost that was apparently approved by the council at the time that was not expended. Would that be fair? So just to be clear.
Further? Nothing further. Thank you, County Commissioners. Jeremiah. It's nice news. They gave some money back. Appreciate that. Okay. Anything else for public comment?
Yeah, Mr. Chairman, we have Carrie Agin online again,
Okay.
who wishes to comment.
Carrie?
Hello?
Go ahead, Carrie.
Great, thank you, Chairman. So this is Carrie Agin, geoscientist and retired BLM geologist again. I have 4 questions. They should be relatively short. The first one, how does the industrial siting division work with other divisions, or do they? Are there some projects that the ISD is the only one that handles?
Either one of you, please.
Ma'am, this is Jenny Staben, Administrator of Industrial Siting. In fact, what we have at DEQ is when a new applicant comes in with a project, all of the divisions, we work together. We have started coordinating our meetings, but we basically communicate about every project that we're working on to see if these new projects are something that falls within our jurisdiction. And also, and as far as other state agencies, with every industrial siting application, 19 state agencies are notified of the project and are provided the opportunity to comment on that project. Typically, based on their comments, then the division will reach out to those agencies, and if they are not clear in their recommendation of a permit condition, the division will reach out to the agency and ask if they would like to recommend a condition on the industrial siting permit.
Now, is there a way you can take your next 3 questions and kind of combine them?
I don't think so.
Mr. Chairman, just as a matter of protocol, this is a bit unusual. We generally don't allow witnesses to ask questions. So
Fair enough.
I just want to be clear, like we have rules of decorum and this is just atypical.
Right. Okay. I'll give you one more and then we'll let you wrap it up here. Okay.
Okay, I will try to mash all 4 into one. So I don't understand why carbon capture wouldn't be handled under the air quality division. I found that the industrial siting division is the one who handles nuclear waste or nuclear.
That isn't our top, ma'am, this isn't on topic. We're going to have you offer a closing comment and then we're going to wrap it up here. Okay. Could you offer a closing comment? Not a question, but a comment. Public comment.
I have questions. Well, okay. I
We'll let you
understand.
submit those to the DEQ as a letter. Okay. Let's close it off here. If you have a comment, we're going to do that. If not, we'll just close it off here.
Okay, I will send the comments. Thank you, Chairman. My closing comment is I think it's horrendous that the project proponent apparently is not paying in full for all impacts that the state apparently is paying for some of this. Thank you.
Thank you. Let's go to any further comments either from the room or online. Okay. Thank you. We appreciate you joining us today. This has been an interesting topic. We've learned a lot. Further from the committee?
Mr. Chairman, I think I'd prefer to make a motion on my request to have a bill draft addressing the tribal inclusion for notification, just formally, so I get a sense of committee support. So I'd make that motion.
All right, you got a second? Moved and second. Any further discussion? Okay, there being none. All those in favor say aye.
Aye.
Those opposed, nay. This is a proposal for a bill draft. You'll bring it back next meeting. It's not on our agenda for interim, but it needs to be addressed. Okay, thank you. Go ahead, Representative.
Thank you, Mr. Chairman. And at this time, I'd just like to make a motion that we put together some sort of working group. I think we've heard from the county commissioners that there is an appetite to expand our tiered system to allow the Industrial Siting Council the ability to go outside of those tiers if the council deems it's necessary. So I'd just like to see if there's interest in a working group.
Let's just pull it for just a moment. And I'll just take it in comments. Any others on the committee who would be interested? Okay. You might be by yourself on that committee. All right, you got some help. Anybody else? Okay, I don't know that we need it as a motion, but if you would like to work with the county commissioners, identify yourselves again, please, you and Wally and Jones, and Senator Rappas. Prep that with the county commissioners before next time, okay? Appreciate it. Go ahead.
Mr. Chairman, I'd propose a working group to look on eliminating the statutes on unmitigated impacts.
Want to tie this in with him or you want to?
Oh, no, separate.
Okay. You have any friends?
I doubt it. Okay, Representative Heiner.
Okay, you got one. Oh, the professor is at work today. Okay. All right, you have at least three? All right. Doesn't need to be a motion. You just got a working.
We'll
group.
just do it.
Okay. Absent objection, you folks work on that. Thank you. Let's do this. Thank you for your time. Well informed.
Thank you, sir.
This has been very informative. Thank you. Folks, we're going to move into the next topic, but I would note this. We have consulted with my co-chair on this. We have some folks that have traveled to testify on Senate File 44. And we want to give them an opportunity to offer comment. We felt like that, but we want to continue with our list now. And so those who traveled for Senate File 44, just patiently wait in your chairs. We'll be there. Okay, abandoned mineland funds, give us an update.
Mr. Chairman, again, thank you. My name is Alan Edwards. I'm the Deputy Director. With me today is Don Newton, the Administrator of the Abandoned Minelands Program. I had thought the last one would go real short. It went a little longer than I thought. I'm thinking I should just leave the table and leave the room. But in the meantime, I'll turn it over to Don for a wrap up, but I had a couple of closing comments at the end of his presentation.
Okay, go ahead, sir.
Don Newton, the Administrator of the Wyoming Abandoned Mineland Division of DEQ. I have just a few points about our program that I thought might be helpful. And then I have a few slides of some of our projects so you can see kind of what it looks like when we reclaim an old mine. And then I'll be open for questions. The Surface Mining Control and Reclamation Act of 1977 allowed the creation of the Title IV program, which is the Abandoned Mineland program, and the Title V program, which is the Active Mining program. Wyoming submitted its first state reclamation plan to the Office of Surface Mining in 1982, and that plan was approved on Valentine's Day in 1983. Wyoming also submitted a certification from the governor in 1984 that Wyoming had reclaimed all of its high priority coal or funded what high priority coal was on its inventory list. What that did is that allows Wyoming now to use its coal fee-based money to clean up non-coal projects, uranium projects, gold, precious metals, things like that. So going over a little bit of the funding history, the law came into effect in 1977, and it's gone through three amendments. You can see those up there. You can see the different rates. The majority of the coal in Wyoming is mined in surface coal. It started at 35 cents a ton in 1977, and then you can see the progression of it going down to the latest amendment that we had in 2021 at 22.4 cents a ton. Those funds flow to the federal government, and then 50% of that funding comes back to the state to reclaim abandoned mines. Some things of note in the 2006 amendments, Senator Enzi and Barrasso were instrumental in getting what we call prior balance funds back to the state of Wyoming. And if you recall, that's the money that the federal government had not given back to all the states, that the states were owed. And Wyoming got $579 million in 7 equal payments of $82.7 million. And that money was used by the legislature on projects all over the state. One you might recall is the Gillette-Madison Pipeline project. That was one of the largest projects. In the 2021 amendments, Senator Barrasso negotiated the 20% reduction from 28 cents to 22.4 cents a ton, and also a 13-year renewal where the two previous amendments were for 15 years. One of the other things of note is that the fee-based money that we get is subject to sequestration of 5.7% annually. So that comes off the top of the 50% that comes back to the state before it comes to us. The funds in 2021 that we received were 33 million from the fee-based money, and this year they were 25.2 million. This slide's a little ahead right now, so I'm going to still give you some additional information before we get to that slide. New funding came into the Abandoned Mine Land Division through the Infrastructure Investment and Jobs Act of 2021, also known as the Bipartisan Infrastructure Law. That was 11.3 billion nationally. And the disbursement of that to the states is dependent on what's called the historical coal share. And that's how much coal the states had produced prior to 1977. So the new money in the IIJ or BIL that's coming to Wyoming is 9.6 million per year for 15 years, starting in 2021. But the lion's share of that money is going to Appalachia. Pennsylvania gets 244 million a year for 15 years. And West Virginia gets 140 million a year for 15 years. Those are the two largest states. So, most of Wyoming's coal has been produced since 1977, and that's why Wyoming's share is much smaller than the other states. But, one of the things that does is that 9.6 million a year essentially kind of makes us whole to where we had been since we got the 20% reduction in the fee-based money. Where we spend our funds. Most of our funds are spent in subsidence mitigation, and you're all very familiar with that. The Rock Springs, Hannah, and up in Sheridan. In the last 3 years, we've spent 60 to 70% of our funding in subsidence mitigation projects. They're very costly. And many times it takes many years to handle a subsurface mine. We also have 27 mine fires that we monitor across the state. We just mitigated one just north of Rock Springs last December. So I think we're down to 26. In our non-coal projects, a lot of our money goes into uranium projects, the Gas Hills east of Riverton, Shirley Basin, south of Casper. Those are two of the largest areas, and you'll see some pictures of those shortly. We also have small non-coal projects all over the mountains of Wyoming, some of them at elevation, some above tree line even. And then, of course, we also have emergency projects that we have a hard time planning for. And most of those emergency projects are subsidence projects. The slide that was up on the board, there you go. These are numbers that were generated from what we report to OSM every year for where we spend our money. We don't spend a penny without OSM approval of all of our projects. OSM has a database called eAmless, and so we generated these numbers from eAmless, and you can see this is how much money was spent by county over the life of the program. The left column next to the county column is the total amount that was spent. And you can also see, if you move over to the far right, you'll see the public facilities costs per county. You're familiar with the public facilities projects that we've done over the decades. When we have funds, when we have funded all of the projects that we have on our list for that year, if we have leftover money, we can do what's called a public facilities project. The last one was in 2019. We had around $20 million that was left over, and we did 10 projects around the state. So you can see that in Wyoming, we spent $110 million on public facilities projects. You can see the prior balance funds in there, and that's what the legislature used. So I wanted to show you just a couple of pictures from some of our projects. The first one, the top right picture, is the Little Medicine Bow River in Shirley Basin. The Shirley Basin uranium project was a very large 3,500 acre uranium mine site. They actually redirected, they moved the river about 3 miles because some of the best ore was right under the river. And this caused incredible down cutting up to 50 feet in the river. And this project started in 1986 and it ran to about 1993. And it was the first large non-coal project in Wyoming. That project moved 33 million cubic yards of material for a cost of $33 million. You can see the bridge on the right. That's what the bridge looked like before. Obviously, we couldn't do the project with a bridge in that condition. So the AML program built County Road 2 bridge that you see there, and that's part of the reconstructed stream. Next slide. This is an example of one of our smaller projects. We have these scattered throughout the mountains of Wyoming. This is a vertical shaft. This is west of encampment, about 6 miles. And one of the processes we do for all of our projects is we have to get NEPA clearances. And one of the things we have to evaluate is, do bats use the abandoned mines? Because as you're aware, there's bat issues all over the country. There's endangered bat species. And so this is an example of what a bat closure looks like. so the bats can actually fly out of the mine, come and go and use the mine. But people can't get in it and hurt themselves. Okay, next slide. So this is in the Gas Hills, 35 miles east of Riverton. The Dayloma uranium pit, again, is in a very large uranium mining district. This is phase, it's currently in phase 16, but this is probably around phase 13. This is just one small portion of this very large project. This pit has about, those high walls are about 300 feet tall on the left side. The pit's about 100 feet deep. And the next slide will show you what that looks like after we've reclaimed the pit. So we work very hard at revegetation and replacing the surrounding contours. So, you would.
He's impressed with your work. He wants to come.
Well, Mr. Chairman, I've been out on that project. Mr. Newton was kind enough to give me a tour a while ago. And he's being very kind to himself. This was a fantastic project. And if you look, you can see the original creek course that goes through there that was reestablished by the reclamation. And I don't know how you took that other picture. The pit water looked a lot worse when I was out there. But the department has done a fantastic job. Mr. Newton and I have talked about getting some of the committee on an informal tour out there to see some of the other work going on. And for the department's benefit and just a thank you, they've won national awards for some of their reclamation work and some of the concepts they've used. You can't tell this from original native. It does not look like reclaimed land. So to you, the department, thank you.
Mr. Chairman, thank you.
And if I may, I'd offer, I'll relay that comment to the director, but unfortunately, I think he completed Don's performance evaluation last week. I do want to make a mention.
$1 short.
I do want to make a mention here, though, too, that like the Dayloma pit is pretty much so adjacent to existing core sage grouse area. And so this was a wasteland. So by reclaiming it, at least provides another pathway for sage grouse, which we would like to think aids the state as a whole.
Yeah, very good.
And Mr. Chairman, if I might, just for the committee, if you're interested in that tour, we'll get that set up sometime during the good weather part of the year, both days.
90 days.
Yeah, and go out there and take a look at some of the reclamation if you're interested in that.
Okay, go ahead.
Yeah, and that project is in phase 16 and it has one more phase and then that project will be complete. So that's be 17 or 18 years of work out at that site. One other aspect that that we work in is called the Native Plants Project. And this project was kind of a casual conversation or a casual comment by my predecessor sitting next to me at our fall conference meeting with the Bureau of Land Management. BLM is a great partner of ours. We do, most of our projects are on public land. BLM, Forest Service, a few on state lands, but the partners that we have, private, federal, and state partnerships, the BLM, the Nature Conservancy, we've partnered with an organization called the Institute for Applied Ecology out of Corvallis, Oregon, and the Wyoming Department of Corrections. The way I view the Native Plants Project is like a three-legged stool. The first is what you're looking at now is a seed research lab in Lander. And we fund a portion of a botanist and actually a couple of botanists to look at how we can be more effective with our work. Because the final product we don't just grow grass. We want the final product to look like the undisturbed land in Wyoming, for wildlife, for grazing, for every opportunity that we can use the land for. The next slide is the second leg of the stool, is the partnership we have with the Department of Corrections. We grow about, or excuse me, they grow about 30 to 40,000 sagebrush plants a year that are planted on our mine sites and also on other BLM reclamation sites that BLM is doing. So BLM is our partner on this, and the Institute for Applied Ecology provides a seed researcher to work with the inmates to teach them how to do it, teach them how to cultivate the plants and then how to plant them. The inmates actually get to go out and plant these. Yeah, and yeah, you're right. OSM is also another federal partner. The next slide is our third leg, and the BLM has a mandate to do public outreach. And our partners at the BLM and Lander created a partnership with the Lander Middle School. And what we do is we go and we teach the young science students about the importance of the sagebrush step, how it is critically important to all of Wyoming, and then they get to go out and plant plants themselves. And probably the best aspect is we get a lot of volunteers to help us with this. A lot of scientists. So these kids get one-on-one or two-on-one with a scientist that works in reclamation. And we think that's a great education for the kids. Another aspect of our revegetation work is the Wyoming AML Vegetation Evaluation System, or WAVES. And what we're really trying to do is to critically look at the success or lack of success on our projects. This system has been developed in-house in conjunction with industry, and that's the oil and gas industry, the mining industry, all the federal partners that work in reclamation. And so what we're trying to do is learn from what we've done, both good and positive, good and bad, and then try to alter what we do to get the best result for our product and the time we spend out there. But, as I mentioned earlier, the reclaiming, the landscape in Wyoming is difficult, to say the least. And especially at these mine sites where the soils have just been all mixed. There was no, it's not like current mining where they have a very good plan on how to get to reclamation at the end of their mining, where they segregate topsoil and things like that. We don't have that at these mine sites. So it's a difficult task to get a site to look as good as the De Loma site, like you saw earlier. The last thing I'd like to mention is our relationship with the Office of Surface Mining. We have a very strong relationship with our local offices in Casper. We also have OSM has a new principal deputy director, Sharon Bushino, who's actually out of the UW Law School here. And she has been instrumental in improving the relationship with the AML groups, the AML divisions across the country, and the headquarters of OSM, which we have had some difficulties with over the years. But Sharon has done a great job in critically looking at how we can work together better, which is what we all want the same result. We still have some issues with OSM. We've got some new mandates from them that we don't necessarily agree with. They want us to redo our reclamation plan. We have the newest reclamation plan in the country. It was submitted to them and approved in 2021. We can understand why they want some states to do it because some states' reclamation plans are over 35 years old. But we've redone ours 4 or 5 times over the years. And then there's new metrics, tracking metrics they want with Justice 40 and disadvantaged communities and spending in those areas. And we don't necessarily think that that really relates to the work we do. But with that,
Okay,
I'll take any questions you have.
committee questions? We have one. Go ahead.
Mr. Chairman, thank you. Administrator Newton, thank you for being here. I had a question. In my neck of the woods in Campbell County, there are mines that for boundary reasons or other reasons are looking at their closures. And with that, you've got on the mine site, the pit obviously has been reclaimed as it moves. The maintenance buildings, the loadouts, the warehouse, plants, and finally you're left with maybe an administrative building and a rail spur. And the county has been looking at some of those as opportunities for other industry to come in.
Mm-hmm.
So my question is, with bonding anymore, a lot of those mines now cash bond for reclamation, but they're left with the idea that they're leaving an administrative building and a rail spur. They may be able to leave some of that cash behind to fund that reclamation. But is this something that AML could look at as a project with maybe the county, the company and AML somehow either renewing a bond or creating a future fund? Because the concern I have for the state is that reclamation, as it continues to increase in cost as well, that enough money is left behind to actually do the reclamation. And from the perspective of the companies, they have paid with a bond and they've also paid with every ton of coal that's gone down the track to take care of this. So could you comment on that?
Mr.
Yeah,
Chairman, I'd like to jump into that. We're conflating two issues. Title V, active mining, and AML. And Administrator Wetland is here, and I know he's been working very closely with the county commissioners and with the Nature Conservancy, with all the others to try to address that. But AML funds can only be applied for abandoned mine land programs. It cannot be applied to active mining or reclamation. So there are two separate issues. I would also like to point out, it's one of the things I was going to comment on the end, but if I may, Mr. Chairman, I'd like to jump into that.
Okay.
Just like the pictures that Don showed up here of the AML work, as Don said, the large AML projects have some unique challenges because basically they just dozed everything off. And so it's a real reclamation challenge. But like in the pictures, it leaves the impression that AML may be the only entity doing good reclamation work. The director and I would like to make sure that the committee is clear. A lot of the discussions on AML is because of the associated funding that comes along with it. And as a result of the challenges, there's been a focus on trying to improve that revegetation. We would like to state for the record that the active mining companies have innovated, they have advanced, and they do extremely good work. So the work that AML is doing is not an implication that they're not doing good work. And as a matter of fact, at some point in time, that for those who haven't been on some of the sites, it might be interesting to see the reclamation the active mines are doing.
Okay.
So, and then I do have later a couple of other items to close out for
Okay.
us.
Any other further questions? All right, thank you. That's a good presentation. Incredible work.
Thank you.
Great before and after photos.
So, Mr. Chairman, one thing I'd just like to remind the committee, if you recall, the legislature this last year set up a 30% up to 30% set aside for the bill funding. of the 9.6. So up to 30% a year can be set aside. That money is going to be held so that when the money runs out, and it will, it's getting hard to get money for those programs. There's a funding mechanism to keep the program active, to do mine subsidence and to deal with mine fires. Relative to Don's comments about OSM, Maxwell Smart, I'm gonna revert back to my childhood. Well, my
Some of the table
childhood.
may not know who you're talking about.
Yeah. It's my second childhood. We'll just go there. And the cone of silence. I can vouch for the fact that both AML and Title V would submit documents and they'd go to DC and they would enter the cone of silence, never to be heard from again. Shout out to Sharon Bashino. She went in and she has been working to get the reclamation plans approved. Well, it took the governor a personal intervention to get the last Wyoming AML plan approved and out the door. It had already gone through the system. So there's progress being made on getting things out the door. Title V is still in the cone of silence. The Black Butte Mine Permit Amendment and all the others still go there. They've been there, I don't know how long, the Black Butte. 4 years. It's been there 4 years, continues to change. But I'm not speaking for the director here, so I'm going to give you the deputy director's thought. It's dangerous. We are televised, right?
You are live.
But the work that's being done with AML has established that things can get approved and out the door. It's unfortunate that that same approach is not being applied to the Title V. So on one hand, they've demonstrated that it can be done, and on the other, we're still waiting. So that part gets a little discouraging sometimes.
Understood. Thank you.
Thank you, Mr. Chairman. That's all.
Committee, anything else? Okay, thank you. Okay, that takes us to the end of our list. Any further public comment here? Who said that? Oh. Oh, you want to offer public comment?
I do, yes.
Okay. Go ahead.
Mr. Chairman, Stephen McKnight with Wyoming PBS. I just wanted to highlight real quickly, we worked on a mini documentary about the specifically the sagebrush work that AML and BLM and others are doing. So if you're interested in that, look up the Our Wyoming episode called Saving Sagebrush, and it really highlights the importance of that sagebrush steppe habitat and the work that they're doing. We followed from seed collection to the work they're doing there at the Honor Farm and growing those seedlings and then the replanting. We plan on doing a 30-minute documentary about kind of expanding on that seed lab stuff that Mr. Newton mentioned, and like the junior high students and that sort of thing. So
Okay.
sort of a shameless plug, but if you want more
There's a
information
reference
on
point
that.
for it. Thank
check it
you.
out.
Okay. Very good. Caught me off guard. Thank you. Okay. Anything else, committee? Let's do this really quick to our visitors. Can you stay a little longer here? These folks have been running the full afternoon without a health break. So if everybody's good. Okay, I just need to see if we needed to take a quick 10-minute break, but let's go ahead. Now, what we need you to do is identify yourself with your name and then go ahead and offer public comment. And not a question like we heard earlier, but just public comment.
Thank you. My name is Bruce Lawson. I'm from Casper, Wyoming, and I drove from Casper today to address the committee. Mr. Chairman, members of the committee, on Senate File 44. I did arrive just before 3 p.m. to testify, and discovered that you had rearranged the schedule and discussed Senate File 44-215. So I apologize.
We're just clipping.
I know
along
you've had
there.
a long
Yeah.
day, and I apologize for.
But we're going to give you time.
I appreciate it. So just background, I'm a lifelong Casper, Wyoming native resident. I graduated from UW in 1979, degree in range management with the goal of being employed in the Wyoming mining industry, conducting mine land reclamation. My career in the Wyoming mining industry lasted for 41 years. The first 6 years were in surface uranium mining operations and in situ leach uranium operations as well. 1985, I went to work for Black Hills Bentonite in Casper. I was their mine development reclamation manager for 35 years. My primary responsibility was permitting large-scale mining operations, non-coal regulatory compliance on the mine lands and mine land reclamation. I consider myself an expert in permitting mining operations. I'm here today to tell you that I'm opposed to Senate File 44 as it's currently written. There are a few things in those amendments that I would support in terms of some of the bonding provisions, but I am, from my experience in the mining industry, I'm adamantly opposed to expanding mining of any additional minerals beyond what's allowed at the current time. I have permitted a couple LMOs. One was about 15 miles southwest of KC, and the nearest residence was 5 or 6 miles away, and it was a perfect place for an LMO. I do want to add that I am directly affected by Prism Logistics' proposed LMO on base of Casper Mountain. I've lived adjacent to Coates Road for 41 years. I'm 900 feet from Coates Road, and if Mr. True develops his LMO to the extent that he's proposed, there will be over 48,000 trucks, 25-ton belly trucks going past my property, probably for here till the end of eternity. But my concern about the additional minerals that might be mined, as you may well know, that, under an LMO, all of the baseline environmental analysis that's required under a large mining permit is exempted. So there's no analysis of soils, surface or groundwater hydrology, geology. But my greatest concern is there's no geotechnical analysis of the overburden. And you look at what some of the minerals that may be allowed to be mined. We're talking hard rock minerals that could be gold, silver, copper, molybdenum, rare earths. And since a company would not be required to do any geotechnical analysis of the overburden, we could easily end up in a situation where those mines are producing toxic acid mine drainage. Some of those overburdens contain pyrites. Once they're exposed to air and water and they oxidize, you get mine runoff. You look historically at gold mines throughout the West in the 18th and 19th century, thousands of those mines were small hard rock mining operations that have leached acid mine drainage into streams of groundwater for decades. And that's one of my concerns about opening this up. Right now we look at the minerals that are allowed to be mined under an LO. They're very benign. There's really not any toxic releases associated with shale or gravel or sand, but we're really going to open up a can of worms, open this up to hard rock minerals, especially since there's no baseline analysis, especially geochemical analysis of overburden. But even in the bentonite mining industry where I worked for years, some of those shales in the overburden were capable of producing toxic acid situations. And it's not also a matter of groundwater, surface water quality issues, but we had to be careful even in the bentonite industry of how we replaced those different strata of overburden if there were toxic overburden, because you didn't want to put that overburden directly in contact with your topsoil. Because our primary goal for all of us is successful mine land reclamation, like we just saw in some of those slides. But if you're not managing your overburden and you have toxic overburden, that's in the root zone of your plants, your topsoil, you're not going to have successful reclamation. That's just one of the many concerns that I have where LMOs are exempted from the baseline environmental analysis. In addition to that, if you're following the situation in Casper with Prism Logistics and their proposed gravel mine, we've gathered over 6,000 signatures in opposition to that. But, one of our biggest concerns with that is there's no public process currently with LMOs. So there's no public comment period. There's no public notification. There's a simple public notification period for, a few property owners within, I think, a mile of the proposed project. But there's no opportunity for public comment. There's no detailed mine and reclamation plan. So even if there was an opportunity for public comment, there's nothing to comment on because a detailed mine and reclamation plan isn't even required. So I think one thing we could really do to strengthen the trust of the public in allowing LMOs to move forward would be number one, an amendment requiring a comprehensive mining and reclamation plan. I mean, right now, they don't have to go to the expense of doing any of the baseline inventories and analysis, but the least they could do for the public that is going to have to live near one of these mines is provide a comprehensive mining and reclamation plan, as well as mining and reclamation schedule. And what I'm suggesting would be something to the same detail and degree that's required for a large mine permit application. It's not a difficult thing to do, but that way the public would know exactly what's going to happen, especially the public that lives near one of these mining operations, like the hundreds of people that are going to have to live next to Prism Logistics if that goes forward. The second thing I'd like to see that I think would really help with this, in addition to the public notification, the mining and reclamation plan, is a public notification and public comment period under the Wyoming statute subsection 3611-406J, and that's the same public notification and public process that's required for a large mining permit. And it's a 30-day public notification, 30-day public comment period. But I think that would really help give the public some assurances of what's going to move forward, especially with an LMO that's located near their property, like mine. So, for example, right now, I don't know if you're aware of this, but the current LMO application process is a one-page fill-in-the-blank form. There's no detailed mine plan. There's no reclamation plan. They basically show the footprint of 15 acres where they're going to mine their materials, and that's about it. And the 15 acres excludes access roads they construct. So again, if you're going to amend the legislation that created the LMO, I would strongly urge you to consider requiring a mining and reclamation plan, and also the public notification, public comment period. But the one I don't want to keep you, but one thing I do want to add is in 35 years of permitting mining operations, it was always my belief that I think the LMO originated what was called a 10-acre exemption, and then subsequently it grew to the 15-acre LMO. And it was always my belief that it was intended for a small mom and pop sand and gravel operation in Sussex, Wyoming, or a sole proprietorship. People didn't have the resources and the means and the expertise to, go through the typical baseline environmental analysis and inventory. So I get that, but unfortunately, what I'm seeing now is this LMO process is now it's being exploited by some of the largest sand and gravel mining companies. You look at Knife River, You know, Knife River is a huge corporation. They're in Montana, North Dakota, Wyoming, maybe several other states. So now instead of, you know, the LMO being provided as a tool for these small mom and pop gravel operations, you've got some of the biggest corporations in the state exploiting permitting an LMO, not having to provide anything except, you know, a air quality permit. I know at the State Board of Land Commission meeting April 4th in Casper, LQD and DEQ were there and provided wonderful, important testimony. But, and I heard it again today is, you know, they said, well, they need an air quality permit, water quality permit, but they don't quantify what that water quality permit is. And I think a lot of people walk away and think, oh, you know, they're going to have to get a water quality permit to address groundwater problems. The water quality permit they're talking about is simply a stormwater, a general permit for stormwater. Has nothing to do at all with groundwater issues. It's simply to control stormwater runoff from the surface of these mines. And I'm just disappointed that, you know, there's not more information put out by the agencies on exactly what that water quality permit covers. It has nothing to do with groundwater.
Okay, thank you. You're well informed. And how many mines did you permit? You said in your opening comments, you told us how many permits you had been a part of. How many?
Oh, you know, when I retired from Black Hills Bentonite, I had 7 or 8 large mine permits in 7 counties, and I had over 80,000 acres under active permit with thousands of acres of disturbances from, you know, open pits to stockpiles, you name it. So
Coming to us with experience.
it was overwhelming.
Now you're aware we haven't done anything final. We've called for a rough draft. That gives you an opportunity to study that piece of legislation further. It was amended, but I encourage you once we get that rough draft or not that bill roughed out to bring back into the session or bring back to the committee. I encourage you to take a look at it. But in the meantime, let's see if there's some questions for you or comments. Committee. Did I give you enough time? You spent 2.5 hours, 2 hours and 45 minutes to get here. So did you cover everything you needed?
Yeah, thank you very much. I really appreciate the opportunity to comment in person.
Yeah, appreciate it.
Thank you.
Okay, so track what we're doing. It's still in the process. We'll be back around with our next meeting. When is our next meeting, sir? You know,
July.
what?
Yeah, Mr. Chairman, July 30 and 31st.
Okay, that gives you some time to track the process, okay?
Mr. Chairman.
Go ahead.
Just for clarification, there will be public testimony on the bill at that time also.
Right,
Great. Thank you.
so appreciate you coming down. Safe travels back, okay?
All right.
Okay, thank you. Appreciate it. Committee, anything else? Committee, anything else?
Mr. Chairman, did we have someone else for public comment?
Yes.
Oh, we did. Oh, we had
I
one
thought-
more? Did we have one more?
We had 2.
No, just
Okay.
one, apparently. Brian, is there anything else for the committee?
Mr. Chairman, I'm happy to do a run through of what we did today. I can wait until tomorrow and just do one big run through at the end.
Everybody good for the restroom for another few minutes? Okay, go ahead.
All right, so Mr. Chairman, the committee requested a bill draft based on the Oil and Gas Conservation Commission's request concerning the authority for regulation of water retention pits, a bill draft to extend the manufacturing sales tax exemption by 10 years, a working group, and then a bill draft on sales tax amortization. Chairman Burkhart, Senator Rothfuss, Representative Lawley, Representative Larson. A motion that was approved to revise 25 LSO 1 for the July meeting, the staff comment and the amendment from DEQ to be in that draft. A bill draft for tribal notification for including that in the industrial siting statutes, and then 2 working groups concerning industrial siting 1 related to the tiers for those industrial siting payments. Representative Larson, Senator Jones, Senator Rothfuss, Representative Lawley. And then a second working group concerning unmitigated impacts, Chairman Burkhart, Representative Heiner, Senator Rothfuss. And Mr. Chairman, I'll probably mention this again tomorrow. If those working groups desire bill drafts for the July meeting, it would be good to have that direction early to mid-June to allow time for drafting and then make sure those are posted well in advance of the meeting.
Fair enough. And you, those in those working groups realize you're just zooming, there's no reimbursement. Okay, all right, good.
And then, Mr. Chairman, last comment for the day, and I'll send an email for those members who aren't here. We are commencing at 8 a.m. tomorrow, so another time change.
8 o'clock, a little earlier.
A little earlier, yes,
Okay.
Mr. Chairman.
Thank you, staff. Appreciate everything you do. Committee, anything else before we break? 8 o'clock tomorrow. Okay, thanks everybody for attending today. This concludes our meeting for today until tomorrow at 8 a.m. Recessed until 8 a.m. tomorrow.